enquanto isso, os nossos técnicos vão estar trabalhando no áudio. O problema é mínimo, é um pequeno eco. E espero que os nossos dois colegas, a ministra Justiça Michelle Obosoin, do Canadá, e o ministro Joe Williams, Justice Joe Williams, estejam nos escutando e nos vendo. Imagino que sim. E é com prazer, em primeiro lugar, que eu dou as boas-vindas ao ministro conselheiro da Embaixada do Canadá, o senhor Simon Cridland. Muito obrigado por estar aqui conosco. E o senhor embaixador Richard Prendergast, da Nova Zelândia. Muito obrigado por estar aqui no STJ. Eu e a organização do evento distribuímos a biografia vasta dos dois colegas da Corte Suprema do Canadá e da Nova Zelândia, e, portanto, eu não procederei à leitura dos seus dados biográficos. Quero apenas realçar que os dois participam por vídeo, mas gostariam muito de estar aqui fisicamente conosco. Mas, em breve, este é o plano do STJ e também na Embaixada da Nova Zelândia e da Embaixada do Canadá, nós contaremos com a presença desses dois juízes extraordinários, que são extremamente respeitados, não só nos seus países, mas também na comunidade internacional. A ordem das intervenções, e agora eu já não me lembro, eu imagino que primeiro seria o Joe Williams, mas me corrija se eu estou equivocado. É não só um esquecimento decorrente da idade, mas também do cansaço. Mas eu imagino que é o colega Joe Williams. Houve uma divisão de tema, mas eu não me lembro qual deles que falaria em primeiro lugar. Então, a partir desse momento, vamos abrir o áudio para os nossos dois palestrantes. Enquanto isso, eu só quero lembrar que a ministra Michelle Obosoin é da etnia Abenaki, espero estar pronunciando corretamente, e não é apenas alguém que representa os povos indígenas e o que há de mais moderno no direito, no tratamento dessas questões no Canadá, mas, como eu disse, alguém que nós admiramos profundamente no mundo todo. E o colega Joe Williams é Maori, e aqui também eu não preciso dizer que ele é um orgulho não só para os neozelandeses, mas também é extremamente respeitado pela comunidade internacional.
Me? Can you hear me?
Yes.
I wasn't, two problems. One, I wasn't getting a translation, so it was gorgeous listening to your Portuguese, Antonio, but I couldn't understand who you were calling on to speak. And secondly, I had an echo, but it's gone. Okay.
Great.
So, which of us?
Who is speaking first?
Me?
Joe, you are.
Okay, right.
Yeah. So I was right. Okay, Joe, please.
Okay, good. Thank you. Sorry about this. It's the technical stuff is always hard for someone of my advanced years. It's traditional among my people to begin with a brief invocation, so that's what I am going to do. Tēnei te ara kei ingoa te araurangi e tū nei te arau papa e takato nei. Tēnei te araurangi rāko papa e takato nei. Kia rarau te tapo ai o tāni ki raro, nau mai te pō, tēnei te ao, tihei mauri ora. My name's Joe Williams. I'm from a small collection of islands in the bottom of the Southwest Pacific, now called New Zealand, originally called Aotearoa, often these days called Aotearoa in New Zealand, a kind of hyphenated name that reflects the struggle we're going through. The invocation I used reflects the fact that we are both a sea people and a forest people. And it celebrates the fact that Tāne, the god of the forest, and therefore of the great trees, was the one who separated his parents, the Sky Father Ranginui, and the Earth Mother Papatuanuku, and in the separation admitted light and understanding into the world. The invocation asks that in the comments I'm about to make, I do so in the tradition of Tāne, the great tree, and admit light and understanding into the conversation. Antonio has tricked me twice now. Last year, he got me up at 2:30 a.m. to make some comments to a conference in Stockholm. This time, again, because if he weren't a judge, he would be a car salesman, he got me up at this early stage in my country. You can see it's dark outside. We're heading into the winter. It is 6 a.m. I've been up since 5 a.m. I have a shirt, tie, and jacket on, but I'm otherwise clad in my pajamas. I am, some judges are early risers. I do not count myself amongst that number. But Antonio is such a good diplomat that he got me up anyway. So it is a pleasure to be able to contribute to your discussion, albeit only very briefly. Not much can be said in, I think I have 30 minutes, but I'll do what I can. I don't have There's an old saying where I come from, power corrupts and PowerPoint corrupts absolutely. And I don't have a PowerPoint presentation. I'm just going to talk at you. It might have been better if I did have one, but it's far too early in the morning for me. It's a real honor and a pleasure to contribute to this discussion for two reasons. The two most important areas on the planet now are the boreal forests and the Amazon. The boreal forests in my sister Michelle O'Bonsawin's territory, and the Amazon, at least a part, indeed most of which, is in your territory, Antonio. So the place of Indigenous peoples and forest peoples is not just an issue of social justice and human rights. It is an existential issue. It is an issue of the survival of our species, indeed of many species, and perhaps even the planet. So the Indigenous matters must be located or cited within that wider discussion. What I might bring to your conversation is a comparative understanding. That is, you're not the only place in the world where issues of Indigenous rights have had to be confronted, often fumblingly, even occasionally incompetently, but confronted nonetheless. And so in that particular context, we are brothers and sisters addressing similar, if not identical, issues as judges. So let me talk first about some geography, because you probably know nothing about my country. As I said, we're a group of islands in the Southwest Pacific, the bottom of the Polynesian Triangle, 268,000 square kilometers, 5 million people, of whom about 17% are Indigenous. I'm getting someone talking into my... Can you all hear me?
Yes, we can hear
Antonio?
you very well and see you very well.
I'm getting some interference in my microphone. Anyway, so a small country, 5 million people, about 17% of whom are Indigenous. The last of the largest land areas to be colonized by people, by my ancestors, about 1,000 years ago. And then contacted and colonized again by the British in the early 19th century. So New Zealand has been a British colonial possession, and then an independent but still quite British nation state since 1840, when a treaty was entered into between the British Crown, Queen Victoria, and the Indigenous chiefs of my country, called the Treaty of Waitangi, in which it was promised that the Indigenous peoples' rights to their land and rights to self-government would be protected, in exchange for which New Zealand would become a British imperial possession. So I guess comparatively speaking, we got visited by the white people about 200 years, 150, 200 years after you did. But the same process ensued, steady dispossession of the land base, in our case, 15 years of all-out war with British imperial troops that didn't go well for my ancestors, and then the swamping of British immigrants so that by the end of the 19th century, the 200,000 Maori who used to live on the islands had become only 40,000, and the British settlers outnumbered them by 3 or 4 to 1. By the 20th century, my people owned only 5% of the land base they once owned. Their tribes were destroyed. That's not an overstatement. Destroyed because tribal was the primary barrier to colonization, and Maori life was individualized, deculturized, and anglicized. So, our constitution, as it might have been described in the 1980s before the next phase of our development, was one of a unicameral sovereign parliament. That is, a parliament with one legislative house and no constitutional controls, at least no controls that could be enforced by judges. Effectively, no written constitution. The common law, the British common law, rather than the civil law with which you're more familiar, was the law of the land. And the Maori dimension in my country was effectively reduced to 4 ethnically based seats in the legislature called the Maori seats, in a house of about 100 seats. So by 1980, let's say, the prognosis for Maori survival, for the survival of Maori rights, for the survival of Maori attitudes toward the land, the sea, the rivers, the mountains, was not good at all. Yet in the 1980s, there came a reawakening. The return, due partly to the rise in the Maori population from that low point of 400,000 to now around 750,000, projected to be 1 million by the middle of the century. The rise of the Maori demograph, the search in my country for its own independent post-colonial identity, that search is not to be misunderestimated, but that's George Bush's word, is not to be underestimated. When I grew up, you would have thought New Zealand was located somewhere just off the coast of England, somewhere between England and North America. And by the 1980s, New Zealanders tucked away in a place that couldn't be further away from England, engaged in a search for themselves. So we saw the return of the tribe as a unit of political policy. We saw the steady mainstreaming of Maori culture and the Maori language as items of national identity. And we saw more recently in the 21st century the infusion of Maori custom into the development of the law, not just as it applies to Maori people, but more generally as well. Sorry, if that's the interpreter, you're talking to me in Portuguese. But despite those, what might be called positive post-colonial developments, the maintenance of stubborn social dysfunction, inordinately high levels of Indigenous incarceration, of the removal and breakup of Indigenous families, of poverty amongst Maori people, of extraordinarily poor educational performance, health performance, and so on. In other words, the social dysfunction that inevitably and inexorably results from the process of colonization itself. So we are caught on the cusp of disaster and nirvana, and struggling with the path we should take to ensure we avoid falling off the cliff and instead achieve the development of a national narrative that locates itself in the Pacific and in Polynesia and becomes comfortable with itself. That's the point at which my national dialogue teeters as I speak to you. Part of that story is underpinned by the last 40 years of the state accepting that the colonial claims of Indigenous peoples in respect of the loss of language, culture, resources, and sovereignty needed to be addressed and dealt with, that Indigenous views of the environment needed to be inculcated into the law and made real, and that the Maori dimension of my country needed to find a place in the national narrative. The last 40 years has seen that development. So more recently, and this will be something that may be of interest to you, our legislature has recognized for the first time the legal personality of a river, one of the most iconic rivers in the country, of a forest inhabited by an Indigenous people, and coming up, the recognition of the legal personality of mountains. These ideas seem to be radical in Western legal thought, are utterly orthodox in Indigenous legal thought. And so the Indigenous people of my country come to feel that those who have inherited the legacy of the colonizer are finally beginning to catch up. The role of the courts in this road to recovery has been utterly crucial. For the last 30 years, the Apex Court in my country has engaged, as it has in Canada and in Australia, the two places that I know best, in difficult dialogue with the legislative branch. I often think of it as two porcupines cuddling. The courts have been the supervisor of the executive branch, giving effect to the recognition of our original treaty and developing what might be called the state's response to the challenges of the time. The courts have been supervisor of that for consistency with Indigenous rights as they might be seen. In all of this, the courts, and particularly the Apex Court, has had to deal with politically charged and difficult issues of policy, while staying in our judicial lane. That has not been easy, but it is crucial for the legitimacy of the courts that the role they play in the development of this national project be protected. In order, and this is my last comment before I hand over to Michelle, in order for the courts, Mr. Interpreter, I can still hear you. In order for the courts to perform that function, that what has, at least in my country, been in some ways the crucial function in the last 40 years of a slow but inexorable process of decolonization, judges have to understand their history, and they have to understand it well. The problems in the past in my country has been with colonial judges who not only had no idea of history, but had no desire to know it. For it was not a history that assisted the project. It is also important that judges understand the comparative context, which is why I feel I can contribute. A great deal of the process of the last 30 or 40 years in my country of discovering the role of indigeneity, not just in the national project, but in the law, has been a remembering that New Zealand's colonial story is part of a much wider narrative. I've spoken about the connections to the Canadian story and to my sister Michelle, to the Australian story, of course, to the American story. These are the Anglo-colonial stories, and there will be a wider dialogue about which I'm only vaguely familiar in the Latin American world, but the issues that the story, let's put it that way, the story that is your story of colonization and the story that is my story of colonization are always, in the end, strikingly similar and strikingly familiar. And it is by understanding that and how other countries have responded to the very same drivers that judges will be better equipped to make good choices within their lane in their role. There is, of course, the need for empathy and humility. Humility about the judicial role and empathy about the people whose lives you're affecting, both Indigenous and non-Indigenous. And finally, and perhaps most importantly of all, the need for discipline and technical skill so that we are judges who apply the law as we see it, not our personal choices, good or bad, whatever they might be. I'm hoping one day to come visit you, to see and learn and fill my kit, as we say, my kete, with more comparative understanding of one of the most important places on the planet right now. I also invite you to come visit me. We may be small and unimportant, but sometimes you can learn from small and unimportant things. Tēnā koutou katoa. Thank you very much.
Many thanks. Many thanks, Joe. Before we hear Michelle, just 2 comments, if I may, so we don't miss the complexity of Joe's presentation. The first is about us as judges. I make a distinction between judges of colonies and colonial judges. And to me, to be a colonial judge is much more detrimental to the public interest than be a judge of a colony. Because being a colonial judge has to do with the mindset, has to do with the intangible. You inherit something, and often you don't know that you inherit it. And this can be very dangerous from a constitutional and legal perspective, because you might, without knowing, be challenging with your decisions what's written in the Constitution, in the laws, and in international law. And the other point that Joe made is about humility. And we judges are not well known for humility, as you know. But I think it's absolutely crucial, as we learned yesterday and today, may I say, with my brothers and sisters from the Brazilian indigenous people, that law is much more than just law. And we have to embrace different cosmologies, different values, and often they are not different because they are already part of the legal system, but we cannot read them properly. And that's why we need events like this. Michelle, please. And thank you, Joe.
Yes, can you hear me?
Yes, we can hear and see you very well.
Okay. Kwai ni dobak na deliwizi mi seliso bansawin na zawia dana kwabanake kalnobab taplawinonia. So I, like Joe, start off by introducing myself in my indigenous language, which is Abenaki. My name is Michelle Obanswin, and I am from Odanak First Nation. We are the Abenaki people. Odanak, for those of you who absolutely don't know, I guess, it means in my village. And I'm part of the Turtle Clan. So I'm really happy to be with you today. I'm speaking to you from Ottawa, our capital in Canada, which is unceded Anishinaabeg and Algonquin territory. And for those of you that may be wondering, I am fully clothed. I do not wear pajamas because I'm at work. So by way of background, I would start off by telling you that in Canada, we have approximately 630 First Nation communities. And of that, we have about 50 First Nations. So Odanak and Wolinak, our sister nation, is part of those 50, including also approximately 50 languages. And one of the issues that we've been facing, our First Nation communities, is that with the passing of our elders, so is our language. And that relates directly to one of the major issues that we've had here, which deals with residential schools. So those of you that aren't familiar is in the last century, the government of Canada would actually take Indigenous children from their communities and place them in most of the time where they were religiously run schools. And the goal was basically to beat out the Indian out of the child. So it was to lead to assimilation, so the children would not be practicing their culture and learning their language. So unfortunately, this has led to significant issues in our communities that have to do with identity issues, where people don't know what their culture is anymore, having issues with maintaining language, more serious issues like addiction, mental health issues, violence within our communities. And a lot of our 50 plus First Nations have really taken it upon themselves to work to revitalize our First Nations languages. And my community, Odanak, is one of those, because we have, I think, only a couple of handful of elders that still fluently speak Abenaki. And I myself I am a product of the revitalization of the language on our land, because for the past 2.5, almost 3 years, I've been actively learning it. And some cousins from New York and Maine have put together teachings that has permitted many of us to learn our language, because one of the instructors went to our First Nation and spent, I think, over a couple of years actually recording all of our elders speaking, so that when we're learning our language, we don't only see it on paper, because as you know, it wasn't a written language, but we actually get to hear our elders speak from the dead that actually help us with pronunciation and intonation. And I'm really fortunate because I just came back from Joe's land, and what really struck me there is that there, with the Maori people, is it's one language, it's a commonality. I know there are different dialects, but it struck me because everywhere I went when I was there, I would see a lot of things that were related to the Maori and their culture, whereas here it's really different. It depends where you go, but that does happen. And to give you an idea of how we're set up is our Constitution recognizes our rights under Section 35, and we are set up through three big nations. So First Nations, which are the Indigenous people of Canada, and as I said, that's part of those 630 First Nation communities. But then we also have the Métis people, and the majority find their roots out of Saskatchewan and Louis Riel. And then the third part of our population are the Inuit that live mostly in northern Canada. So we're three distinct groups, so we have a lot of commonalities because we are the first peoples of this land. But one of the issues quickly I'll talk about is that I talked about the issue of residential schools, and in May of 2021 here, there was a finding of remains of 250 children that were found buried in back of a former residential school in Kamloops out in BC. And I think that was a large awakening for the Canadian population, because although there has been quite a lot of discussion about residential schools in the last 20 years, because we've also had quite a few commissions that have looked into a lot of related issues to Indigenous people, like more in the last 20 years, the Royal Commission on Aboriginal People. More recently, we had Maurice Sinclair's commission, the Truth and Reconciliation. We had the Missing and Murdered Women and Children and Girls. We also had the Vieille Commission out of Quebec, and these have all looked at all kinds of systemic racism issues and discrimination and the effects of colonialism and the impact that that has had on our people, and made a series of recommendations on how to improve, because Joe quickly talked about the issue where they also have high incarceration rates, and we're the same. So Indigenous people were about 1.7 million of our population, which is about 5% of the Canadian population. But the men, Indigenous men, account for over 30% of incarcerated people throughout Canada, and women were close to 50%. So there has to be that discussion with regard to how we got there and the impacts of residential school and colonialism. And it's leading us down the path where we hear a lot in Canada about reconciliation. So how can there be a reconciliation between the non-Indigenous and Indigenous people? And that leads me to more of a technical issue, which is the issue that I've been asked to speak about, which is the fiduciary relationship between the government, Indigenous people, and then afterward the duty to consult. So now my presentation gets a bit more technical, because I'm going to talk to you about these legal principles that we've been dealing with here. As you know, I sit on the Supreme Court of Canada, which is the highest court in Canada. We're a panel of 9 judges, and these are the issues that we're grappling with in the last at least 20 years, where it's been 20, 25 years, much more before the courts. And a lot of that stems with, you heard Joe talk about the Waitangi treaty that they have. In Canada, it's the Royal Proclamation of 1763. And I'll just read for you the preamble, because I think it's important to hear it. And it starts off with, as whereas it is just and reasonable and essential to our interest and the security of our colonies that the several nations or tribes of Indians with whom we are connected and who live under our protection should not be molested or disturbed, in the possession of such parts of our dominions and territories as not having been ceded to or purchased by us are reserved to them, and any of them as their hunting grounds. So there are significant issues like you heard from Joe in New Zealand, whereas there was basically appropriation of territory, and in Canada that definitely took place, and in return Indigenous populations were provided with postal, we call them normally postage stamp reserves, where all of the nations were actually forced to live on, so dispossessed of their land. And this Royal Proclamation of 1763 is really important when we're looking at these issues, because the British Crown ended up by placing itself between the Indigenous peoples and the settlers that came to this land, by providing that the Indigenous lands would only be available for purchase by settlers after they had been purchased by the Crown. And this led to the Crown that then afterwards had to accept responsibility over Indigenous affairs and retain the control over the relations with our First Nations that lived under what's called their protection. And that specific authority was later transferred to Canada in 1860. In the 1800s, the legislation that affected Indigenous peoples really suggested the interest of a trust relationship between the government and the Indigenous communities. So there were a series of different acts that were put in place. For example, in 1850, there was an act for the better protection of lands and property of the Indians in Lower Canada. And that had provided for the appointment of a commissioner who was really responsible to deal with the Indigenous groups. And it talked about how there would be a vested interest and trust for each tribe and as they were called, the tribe or body. Then afterwards, that led into the different versions of the Indian Acts. The Indian Act, for you to know, still remains in place right now and deals with almost everything related to Indigenous people. And specifically, and I'll just quote it here, it dealt with all reserves for Indians or for any bands of Indians or held in trust for their benefit shall be deemed to be reserved and held for the same purposes as before the passing of this act, but subject to its provision. What happened, though, is that, of course, the case law was not too clear about the trust obligation. So what's the fiduciary obligation between what in Canada we call the Crown, so the government of Canada, and the Indigenous communities? And the question is then, was it merely a political or a moral obligation, or was something more than that? And that led our Supreme Court of Canada in a case called Guérin versus the Queen, where our court determined that, in fact, it was more than that. There was a fiduciary relationship that was created between the Crown and the Indigenous peoples of Canada. So that then led, we have a federal regime on all federal legislation throughout Canada. We also have provincial and territorial governments, and it recognized that not only federally, but also the provincial and territorial governments, they have a duty to act in the best interest of Indigenous peoples when they're looking at different issues like resources, land, etc. We see it also, for example, there's a lot of mining issues and resource issues, and these are when these matters come up, where basically there's a fiduciary obligation from the Crown to respect the reserve land and to make sure that whatever is negotiated is also in the best interests of Indigenous people. In 1982, we had the first creation of our Constitution Act in 1982, and more specifically, I talked to you originally about Section 35, because that deals with the obligations that arise out of the fiduciary relationship, and so that really entrenches that notion in our Canadian Constitution. And specifically, Section 35 says that the existing Aboriginal and treaty rights of the Aboriginal peoples of Canada are hereby recognized and affirmed. So that led to our court, again, the Supreme Court of Canada, to look at what does recognized and affirmed mean in Section 35. And a case called R versus Sparrow first dealt with that, where there was the incorporation of the fiduciary relationship and important the restraint on the exercise of the sovereign power. So it was very, it was bringing the issue of the review of Section 35 to the forefront, and really is a helpful interpretive tool for lower courts to understand what Section 35 means. And that led to the special fiduciary relationship between the Crown and Indigenous peoples were really grounded in the honor of the Crown. So what's the honor of the Crown? Well, that derives from the Crown's assertion of sovereignty in the face of prior Indigenous occupation. So all of the First Nations that were originally here prior to contact, and then that led to then the de facto control of that land and resources that were really in the hands of Indigenous people prior to contact. And according to the interpretation of the Supreme Court, well, it now requires the Crown to act honorably in all of its dealings with Indigenous peoples, from the assertion of sovereignty to the resolution of claims and the implementation of treaties. Because in Canada, we have certain Indigenous communities that had negotiated treaties with the government. So this leads us then to the issue of the duty to consult. And in Canada, it's very clear the Crown has a duty to consult when it's appropriate. They have to consult as Indigenous groups when it contemplates the conduct that could adversely affect or potentially or even establish Aboriginal rights or interests. So it's really that issues rooted in what I've just spoken about, the honor of the Crown. And the duty to consult in Canada is a doctrine, and it provides the opportunity to recognize and protect the various asserted Aboriginal interests from unilateral Crown action before they're even proven to exist in court. So there does not have to be a proven existence of an Aboriginal interest in order for this even to be brought up. Because if these issues aren't dealt with initially, by the time it's a done deal, well, the interests of the Aboriginal people haven't actually been appropriately considered. And if this duty to consult isn't in place, well, then the Indigenous groups that seek the protection of their interests, they have to have that determination of their claim or the final settlement. If that would have to take place at the early stage, well, then they'd have to start litigation. They'd have to seek injunctions to halt Crown action. It's very costly, and it's really not feasible because throughout Canada, a lot of the funding for the different bands and First Nations do flow from the government. And they're not necessarily funds that come for litigation, for example. These are funding for different issues like health, education, definitely not for litigation. So what happens is that then you have these remedies, well, they're time consuming, they're expensive, at times they're ineffective because the Indigenous groups, they have limited success in obtaining injunctions to protect their interests and treaty rights. And I'm just going to quote from one of our most recent cases from the Supreme Court called Haida Nation versus British Columbia. And this was a forestry issue. And so I'm just going to read the quote. The Crown, acting honorably, cannot cavalierly run roughshod over Aboriginal interests where claims affecting these interests are being seriously pursued in the process of treaty negotiation or proof. It must respect these potential yet unproven interests. To unilaterally exploit a claimed resource during the process of proving and resolving the Aboriginal claim to that resource may be to deprive the Aboriginal claimants of some or all of the benefit of the resources, and that is not honorable. So this leads then to the question, well, when is the duty to consult triggered? Well, it's triggered when the Crown has either one, knowledge, real or constructive, of the potential existence of the Aboriginal right or title, and two, it contemplates the conduct that could adversely affect it. So the threshold when a court is looking at this is informed by the honor of the Crown. It's not a high one. So the claim of an Aboriginal title or title has to be credible, but it hasn't, again, have to be a proven claim. And I just repeat, the threshold is a lower one. So it leads us then to the next question. Well, what's actual and constructive knowledge? So actual knowledge is triggered by the duty to consult. It arises when a claim's been filed in court, or when it's advanced in the context of negotiations, or even when a treaty right could be impacted. And constructive knowledge arises when an impact on Aboriginal rights could reasonably be anticipated. So when also where we have lands that are known or reasonably suspected to have traditionally occupied by an Indigenous community, that is what we have as constructive knowledge. Then we have to look at, well, is there an adverse impact? And to demonstrate, for a First Nation to demonstrate that an adverse impact could be had, the First Nation has to show that there's a causal relation, so a link between the proposed government conduct or the decision and also the potential for the adverse impact on that pending Aboriginal claim or right. And the adverse impacts that triggers the duty to consult extends to any effect that could prejudice a pending Aboriginal claim or right. So what are the requirements for the duty to consult? Well, really what happens is whoever is going to impact these potential Aboriginal rights, there has to be a consultation process that's taken in good faith. There has to be a commitment required to meet its obligations of honor the Crown. So it has to be meaningful consultation, and it can't be to lead to a particular outcome. So if there are, for example, sharp dealings where when a government entity is trying to mislead an Indigenous community, that is not going to be tolerated by the courts when they're looking at this issue of a duty to consult. And just, I'm almost at the end here, but looking at what is the minimum requirement for a duty to consult? Well, it really requires there to be a notice that's provided to the effective Indigenous groups. And there has to be an openness by the part of the Crown or government of the possibility of accommodation. So the content of the duty carries with the circumstances, so it depends on what the situation is. It's generally proportionate to a preliminary assessment of the strength of the case that really supports the right of the Aboriginal right or the title. And there's a look at the seriousness of the potential adverse impact that such a decision could have on the right or the title claimed. So I see now we're getting close to the end. I'll stop there, but I'm definitely open to any questions. So Uliuni, merci beaucoup. Thank you for listening.
Muito obrigado. Infelizmente, nós não vamos poder fazer um debate por conta do painel seguinte, que é a palestra do presidente da Corte Interamericana de Direitos Humanos, que será presidida pelo meu colega ministro Paulo Sérgio Domingues, que já está aqui conosco. And I'll switch to English because I don't know if this has been translated. Is it translated? To Joe and Michelle.
I heard the beginning of translated.
Oh, good. Então, eu vou falar em português. As duas intervenções foram bastante complementares.
Were very complementary between the two, between themselves. One pretty much added to the other. And my colleagues were here today representing the Indigenous peoples, as well as experts in legal matters. subject matter experts will agree with me in that much of what was said here today can be directly applied to the Brazilian reality. So more specifically, as regards the presentation given by my colleague, Michelle, the presentation touched upon points which have already been mentioned by other indigenous speakers who spoke before in this session. Two of whom are at the head table. I have not introduced you to Chai Surui yet. But Chai Surui is one of the most outstanding leaders. Virtually graduated from law school, right? Chai Surui, one of the towering figures and indigenous leaders in our country. So it's really a reason for much pride for me to hear her speak on the occasion of the opening of the Glasgow Conference of the Parties recently. She spoke so beautifully. She spoke on behalf of all of us. And that is extremely important. I mean, we're talking about the very voice of the indigenous peoples being heard, and especially the voice of young people. Michelle started the presentation referring to the topic of language, and the tribal chief himself mentioned that aspect earlier in previous panels. And reference was made to the fact that there is no more violent form of aggression or destruction of an indigenous people than attacking its own language, although it may not seem to be that violent. Of course, the territory is important in itself, but the fact is that communication with the indigenous cosmology or world vision is done through language. I mean, the stories, the narratives, they all reside in language. And that is why it is so important for us, Brazilians. Also, as we have heard, equally important for the indigenous peoples or the Aboriginal peoples of New Zealand and the original peoples of Canada. It is to look back in history, but never forget your language. In Brazil, we have a huge number, and the subject matter language experts will agree with me, those of you attending this event. You know, Michelle, in this country, we have 4 times more indigenous languages in Brazil than in Canada. And languages, by the way, are not dialects. And some of these languages, as photographer Sebastião Salgado can confirm, some of these indigenous languages are spoken by few people. At times, only 1 or 2 people speak the language. And recently, one of these languages was extinguished, a huge loss, not for that one indigenous people, but for all of us, for all of humankind. We then heard Michelle refer to the territory and the legal framework and reference section 35. And she also referred to fiduciary duties, all of which, of course, applies here to our reality in Brazil. So we have, as you can see, 3 different countries located in totally different geographies vis-a-vis Brazil, and they're totally different indigenous peoples, respectively, different in terms of their history, in terms of their languages, traditions. And the fact is, nevertheless, that the legal issues that they experience are extremely similar. And I think it is fair to say that increasingly the legal responses are likely to prove increasingly similar as well. In conclusion, we heard Michelle refer to the duty to consult. And that is perhaps one of the areas where most progress has been made in Brazil. As regards the large development projects, there has been tremendous resistance or reluctancy in complying with the law and the provisions that are contained in international treaties or instruments. So I would think that these 2 lessons that we have just been given, lessons in comparative law, are just the beginning of a much broader dialogue, a much broader ranging dialogue between the Brazilian judiciary, the Canadian judiciary, and the judiciary of New Zealand. This dialogue must take place among justices or judges. So we are not judges of the colony, neither are we colonial justices. Each of the three countries in this panel have, of course, exceptionally high quality laws and outstanding pieces of legislation in effect. And we must, of course, understand the content of all of these laws and this body of um, legislation. So with that, thank you so much to my two colleagues who have joined us by video conference. The next time we do expect you to come in person. I would also like to voice our thanks to the two embassies. The two embassies have already voiced their commitment to make sure the experts are brought here in person. And I want your commitment to be made public and conveyed broadcast to the whole world. The two embassies have already indicated that they are willing to continue the dialogue. It's really too bad that Michelle and Joe have not been able to attend the other talks and presentations by other subject matter experts who are themselves indigenous, among other speakers in the symposium. Through their wonderful narratives and presentations, they have taught us so many lessons, both yesterday and today. We, as judges, are extremely grateful to all of these speakers and, and also to the two of you. Thank you so much. So with that, we'll bring to a close this panel session. Without further ado, I would like to invite us all to leave our current positions, except for the two of you, because you will remain in the next panel session. And we will have Mr. or rather Justice Sergio Rodriguez, who will be presiding over the next panel session. And I wish to strongly thank my two dear friends and colleagues, Joe Williams and Michelle Obansa-Gwen. Thank you so much.
Thank you.
Senhoras e senhores, em continuidade aos simpósios, participam deste painel que abordará o tema Povos Originários na Perspectiva do Sistema
Our International Symposium, Original Peoples from the Perspective of the Inter-American Human Rights Court. As moderator, Justice, member of the Superior Court of Justice, Paulo Dominguez, and our keynote speaker will be the President of the Inter-American Human Rights Court, Judge Ricardo Manrique, who will be attending this session by video conference. Justice Paulo Sérgio Domingues não has before. Good afternoon, everyone. It gives me great pleasure to be with you all in this event, an event that has triggered a lot of comments and opinions among members of the bench and the judiciary at large as a result of the discussions being held here. I would like to thank Justice Benjamin for the invitation, and I wish to greet my colleagues and friends. It's a pleasure to be here with you all. Without further ado, and given time constraints, I would like to give the floor to our speaker, Ricardo Manrique, whom I would like to greet and welcome to this event. Our speaker, Ricardo Manrique, is the incumbent president of the Inter-American Human Rights Court. He is a lawyer and former minister of the Uruguayan Court of Justice. He has a graduate degree from the University of the Republic on Law and Social Sciences from 1973. In 1973, he started to work as a legal practitioner in Argentina and joined the bench in Uruguay, where he had a long career. He was an appointed minister of the Court of Justice with the Uruguay Court in 2012. Dr. Ricardo Manrique, it is a pleasure to have you here in this panel session, which will last 30 minutes. So you have the floor, Your Excellency.
O som não está funcionando. Agora.
Buenas tardes. Con la moderación de este panel. Mis saludos a la ministra María Teresa da Silva, presidenta del Superior Tribunal de Justicia y demás personas integrantes. A ver, un minuto, si podemos, un minuto, por favor. ¿Ahora me escuchan mejor? ¿Me escuchan mejor ahora?
Ahora sí, sí.
Bueno, perfecto. Bueno, un saludo a la mesa de este panel. Voy a dialogar con ustedes sobre pueblos originarios desde la perspectiva de la jurisprudencia del Sistema Interamericano de Derechos Humanos. Quiero decir que, como todos sabemos, nuestro continente se caracteriza por la enorme diversidad del punto de vista de su población. Hay pueblos originarios que están desde mucho antes de la época del descubrimiento en nuestras Américas y se ha ido avanzando paulatinamente hacia regímenes y sistemas pluralistas que contemplen justamente las diversidades y den una centralidad a la consideración de la realidad de los pueblos indígenas y tribales. En primer lugar, es necesario reconocer las injusticias estructurales que acaecieron contra millones de personas que fueron avasalladas por la colonización, pero además reconociendo las violaciones a los derechos humanos que aún hoy siguen sucediendo contra múltiples pueblos indígenas de la región. La Corte Interamericana ha desarrollado una importante jurisprudencia sobre pueblos indígenas y al respecto es posible mencionar jurisprudencia relativa a temas como derecho a la igualdad y no discriminación, derechos individuales y colectivos, derechos económicos, sociales, culturales y ambientales de los pueblos indígenas, la propiedad comunal, la consulta previa, desplazamiento forzado, acceso a la justicia e impunidad e integridad personales, derecho a la vida, derechos políticos, derecho a la personalidad jurídica, libertad de expresión y lenguas indígenas, entre otros. Voy a recorrer algunos aspectos de la jurisprudencia de la Corte Interamericana, pero quiero empezar esta consideración de lo que a mí me parece básico respecto a los derechos de los pueblos indígenas y tribales, que es el reconocimiento que existe en la Declaración de Naciones Unidas al respecto sobre el derecho a la libre determinación de los pueblos indígenas y su derecho a la autonomía y al autogobierno en las cuestiones relacionadas con sus asuntos internos y locales, y también su derecho a conservar y reforzar sus propias instituciones políticas, jurídicas, económicas, sociales y culturales, manteniendo a la vez su derecho a participar plenamente, si lo desean, en la vida política, económica, social y cultural del Estado. Este es el mensaje que el derecho internacional de los derechos humanos transmite, al igual que las constituciones de los países de la región y de otros países de esta región, en cuanto a la cuestión de autodeterminación de los pueblos indígenas y tribales. Respecto de los principios de igualdad y no discriminación, quiero señalar que la Corte, en el caso Norín Catrimán y otros dirigentes, miembros y activistas del pueblo indígena mapuche versus Chile, estableció que el origen étnico de las personas es una categoría protegida por la Convención Americana. Por eso, cualquier forma, acto o práctica discriminatoria basada en la etnia de la persona es condenada por la Convención Americana. Ninguna norma, decisión o práctica de derecho interno, sea de parte de autoridades estatales o de particulares, pueden disminuir o restringir de modo alguno los derechos de una persona en función de su origen étnico. Un ejemplo de discriminación fue verificado por la Corte en el caso Comunidad Indígena Sacmoc-Casec versus Paraguay, en que la Corte estableció que existía una situación de extrema y especial vulnerabilidad de los miembros de la comunidad debido a varios motivos, como la falta de recursos adecuados y efectivos, que en los hechos protegiera los derechos de las personas integrantes de ese pueblo, y no solo de manera formal. La débil presencia de instituciones estatales obligadas a prestar servicios y bienes a los miembros de la comunidad, en especial alimentación, agua, salud y educación, y la prevalencia de una visión de la propiedad que otorga mayor protección a los propietarios privados por sobre los reclamos territoriales indígenas, desconociéndose con ello su identidad cultural y amenazando su subsistencia física. Asimismo, se acreditó que el Estado no adoptó las medidas positivas necesarias para revertir tal exclusión. En cuanto a derechos individuales y colectivos, la Corte ha distinguido entre los derechos individuales y colectivos de los pueblos indígenas. En el caso Masacre Plan de Sánchez versus Guatemala, la Corte consideró que, dado que las víctimas de dicho caso son partes del pueblo maya, un importante componente de la reparación individual era justamente la reparación colectiva en cuanto pueblo. En el mismo sentido, en el caso Saramaca versus Surinam, la Corte indicó que, dado el tamaño y la diversidad geográfica del pueblo Saramaca, y en especial la naturaleza colectiva de las razones que se ordenaron, no era necesario nombrar individualmente a los miembros del pueblo Saramaca a fin de reconocerlos como parte lesionada. Es decir, la Corte tiene esta noción de que el pueblo como entidad, el pueblo indígena como entidad colectiva es en sí mismo quien tiene representación y personalidad como para ser considerado víctima en los casos internacionales. En cuanto a los derechos económicos, sociales, culturales y ambientales de los pueblos indígenas, la Corte ha reconocido paulatinamente desde 2017 en adelante la justiciabilidad directa de estos derechos ante el Tribunal Internacional. Un caso de referencia es el caso Comunidades Indígenas, miembros de la asociación La CAUNAT, Nuestra Tierra versus Argentina, en el que la Corte desarrolló los derechos a un medio ambiente sano, a la alimentación adecuada, al agua y a participar en la vida cultural, declarando la violación del artículo 26 de la Convención Americana en relación con el artículo 1.1 de la misma, a partir de la afirmación de la indivisibilidad e interdependencia de los derechos humanos, tanto civiles y políticos como económicos, sociales y culturales. Respecto al derecho a un medio ambiente sano, la Corte indicó que diversos derechos pueden verse afectados a partir de problemáticas ambientales y que ello puede darse con mayor intensidad en determinados grupos en situación de vulnerabilidad, entre los que se encuentran los pueblos indígenas y las comunidades que dependen económicamente o para su supervivencia fundamentalmente de los recursos ambientales, como las áreas forestales o los dominios fluviales. Respecto del derecho a la alimentación adecuada, la Corte se pronunció estableciendo que los estados tienen el deber no solo de respetar, sino también de garantizar el derecho a la alimentación y debe entenderse como parte de tal obligación el deber de protección de ese derecho a la alimentación. Correlativamente, el derecho se ve vulnerado por el Estado al no controlar la actividad de individuos o grupos para evitar que violen el derecho a la alimentación de otras personas. Y vaya si los pueblos indígenas conocen de invasiones a sus territorios que cuestionan, entre otros, su propio derecho a la alimentación y a la subsistencia como pueblo. Respecto al derecho al agua, la Corte ha establecido que el acceso al agua implica obligaciones de realizaciones progresivas, sin embargo, de lo cual los estados tienen obligaciones inmediatas, como garantizar dicho acceso sin discriminación y adoptar medidas para lograr su plena realización. Entre las obligaciones estatales que pueden entenderse comprendidas en el deber de garantía, se encuentra la de brindar protección frente a actos de particulares que exige que los estados impidan a terceros que menoscaben el derecho al disfrute del agua, así como a garantizar un mínimo esencial de agua en el caso particular de personas o grupos de personas que no están en condiciones de acceder por sí mismos a ese recurso por razones ajenas a su voluntad. En cuanto al derecho a participar de la vida cultural, la Corte determinó que los estados están en la obligación de proteger y promover la diversidad cultural y adoptar políticas que favorezcan la inclusión y la participación de todos los ciudadanos para que así se garantice la cohesión social, la vitalidad de la sociedad civil y la paz. La Corte indicó que el pluralismo cultural constituye la respuesta política al hecho de la diversidad cultural. En cuanto al derecho a la propiedad comunal, en el caso pueblo indígena quichua de Sarayacu versus Ecuador, la Corte indicó que debido a la conexión intrínseca que los integrantes de los pueblos indígenas y tribales tienen con su territorio, la protección del derecho a la propiedad uso y goce sobre este es necesario para garantizar su supervivencia. Es decir, el derecho a usar y gozar del territorio carecería de sentido en el contexto de los pueblos indígenas y tribales si dicho derecho no estuviera conectado con la protección de los recursos naturales que se encuentran en el territorio. Por ello, la protección de los territorios de los pueblos indígenas y tribales también se deriva la necesidad de garantizar la seguridad y la permanencia del control y del uso de los recursos naturales. Esta conexión entre el territorio y los recursos naturales que han usado tradicionalmente los pueblos indígenas y tribales, que son imprescindibles para su supervivencia física y cultural, así como para el desarrollo y continuidad de su cosmovisión, es preciso protegerla bajo el artículo 21 de la Convención para garantizar que puedan continuar viviendo su modo de vida tradicional y que su identidad cultural, estructura social, sistema económico, costumbres, creencias y tradiciones distintas se vean respetadas, garantizadas y protegidas por el Estado. En el caso Comunidad Garífuna de la Cruz y sus miembros versus Honduras, la Corte estableció que la cultura de los miembros de las comunidades indígenas corresponde a una vida particular de ser, ver y actuar en el mundo, constituido a partir de su estrecha relación con las tierras tradicionales, su cosmovisión, religiosidad y, por ende, su identidad cultural. La Corte ha subrayado la especificidad de la propiedad comunal de los pueblos indígenas frente a otros tipos de propiedad. En Comunidad Moiguana versus Surinam, la Corte dice que los pueblos poseen una relación omnicomprensiva con sus tierras tradicionales y su concepto de propiedad en relación con ese territorio no se centra en el individuo, sino en la comunidad como un todo. En la misma línea, en el caso comunidad indígena Yamaxa versus Paraguay, la Corte señaló la necesidad de que primero, de que la posesión tradicional de los pueblos indígenas de la tierra tiene efectos equivalentes a un título pleno de propiedad. En segundo lugar, la posesión tradicional otorga a los pueblos indígenas el derecho a exigir el reconocimiento oficial de la propiedad y su registro. Y en tercer lugar, los miembros de los pueblos indígenas que por causas ajenas a su voluntad han salido o perdido de la posesión de sus tierras tradicionales mantienen el derecho a su propiedad sobre las mismas, aún la falta de un título legal, y el derecho, en caso de ser expulsado de su tierra, a regresar con todas las garantías a sus tierras. En Comunidad Garífuna Puntapiedra y sus miembros versus Honduras, la Corte reconoció que entre los pueblos indígenas existe una tradición comunitaria sobre la propiedad colectiva de la tierra, en el sentido de que la pertenencia a esta no se centra en un individuo, sino en el grupo y su comunidad, y que tales nociones de dominio y de la posesión sobre las tierras no necesariamente corresponden a la concepción clásica de propiedad, y que ambas concepciones y nociones de propiedad, la clásica y la colectiva, se merecen igual protección bajo el paraguas del artículo 21 de la Convención Americana. Respecto de la consulta previa, la necesidad de consultar a los pueblos indígenas cuando se encaran proyectos que tienen que ver con el desarrollo, que van a afectar la integridad de su medio de vida, de su tierra, su propia cosmovisión. Es decir, la Corte ha interpretado que la consulta, además de constituir una obligación convencional, es también un principio general del derecho internacional. Y en cuanto a las características, la Corte ha establecido que la consulta debe ser realizada de buena fe, con carácter previo y con la finalidad de llegar a un acuerdo de manera adecuada, accesible e informada. La consulta no debe agotarse en un mero trámite formal, sino que debe concebirse como un verdadero instrumento de participación que debe responder al objetivo último de establecer un diálogo entre las partes basado en principios de confianza y respeto mutuos y con miras a alcanzar un consenso entre las mismas. En ese sentido, es inherente a toda consulta, y esto es muy importante, un clima de confianza mutua. Los pueblos tienen que sentir que realmente están siendo consultados con toda su amplitud y que pueden actuar como dueños de su destino frente a la necesidad de una obra pública o de un emprendimiento de desarrollo en el lugar. El Tribunal ha establecido que el derecho a la identidad cultural es un derecho fundamental y de naturaleza colectiva a las comunidades indígenas, que debe ser respetado en una sociedad multicultural, pluralista y democrática. Esto implica la obligación de los estados de garantizar a los pueblos indígenas que sean debidamente consultados sobre asuntos que inciden o pueden incidir en su vida cultural y social, de acuerdo con sus valores, usos, costumbres y formas de organización. En tal sentido, el convenio 169 de la Organización Internacional de Trabajo establece las aspiraciones de los pueblos indígenas, textual, a asumir el control de sus propias instituciones y formas de vida y de su desarrollo económico, y a mantener y fortalecer sus identidades, lenguas y religiones dentro del marco de los estados en que viven. La Corte ha establecido que la obligación de consultar a los pueblos indígenas y tribales está en relación directa con la obligación general del Estado de garantizar el libre y pleno ejercicio de los derechos reconocidos en el artículo 1.1 de la Convención. Esto implica el deber del Estado de organizar adecuadamente todo el aparato gubernamental y de estructurar sus normas e instituciones de tal forma que la consulta a las comunidades indígenas y tribales pueda llevarse a cabo efectivamente de manera necesaria para posibilitar la creación de canales de diálogo sostenidos, efectivos y confiables de los pueblos indígenas y tribales y en los procedimientos de consulta y participación. En el caso Pueblo Saramaca versus Surinam, la Corte estableció que a fin de garantizar las restricciones impuestas eventualmente a un pueblo indígena, se deberían dar 3 garantías. Primero, asegurar la participación efectiva de los miembros de la comunidad de conformidad con sus costumbres y tradiciones en relación con todo plan de desarrollo, inversión, exploración o extracción que se lleva a cabo dentro del territorio. Segundo, el Estado debe garantizar que los miembros del pueblo se beneficien razonablemente del plan que se lleve a cabo dentro de su territorio. La necesidad de una compensación o beneficio por la utilización del territorio a favor de los pueblos afectados. Tercero, la necesidad de que el Estado garantice que no se emita ninguna concesión dentro del territorio, a menos y hasta un estudio previo de impacto social y ambiental. Es decir, consulta, compartir beneficios económicos y estudio previo de impacto ambiental. La Corte ha establecido la importancia de los estudios de impacto ambiental en estos casos, la necesidad de que los estudios de impacto ambiental se puedan compartir en el propio idioma de la comunidad para que los pobladores puedan tomar cabal noción de cuál es la situación a la que se arriesgan de concretarse la obra o el plan de desarrollo que está en proyecto, y en ese sentido que la Corte ha señalado que la realización de consultas es una forma de reconocimiento de la personalidad de los pueblos indígenas, de la personalidad jurídica de los pueblos indígenas. En el caso del pueblo Sarayaku versus Ecuador, la Corte entiende que este pueblo es una entidad tribal distintiva que se encuentra en situación de vulnerabilidad tanto respecto del Estado así como de terceras partes privadas, en tanto carecen de capacidad jurídica y las condiciones para brindar sus derechos. Es decir, la Corte entiende en este caso la necesidad de una salvaguarda de participación efectiva de los pueblos que se requiere cuando se trate de grandes planes de desarrollo e inversión que pueden tener un impacto profundo. Es decir, dice que la Corte que un impacto en la propiedad de los miembros del pueblo a gran parte de su territorio debe ser adicional a la obligación de obtener el consentimiento libre, previo e informado del pueblo según sus costumbres y tradiciones. La Corte, en el caso de Yatama versus Nicaragua, ha tenido oportunidad de pronunciarse sobre los derechos políticos de los pueblos indígenas, señalando que no es posible exigir la constitución de un partido político conforme a la normativa tradicional cuando un pueblo indígena quiere participar en la elección de las autoridades legales locales a los efectos de hacer valer sus derechos. En cuanto a la libertad de expresión y de lenguas indígenas, en el caso López Álvarez versus Honduras, la Corte trató el caso del director de un penal en Honduras que dispuso que un preso de origen garífuna, Alfredo López Álvarez, no podía hablar en su lengua materna en el interior del establecimiento carcelario, respecto a la Corte, de lo cual la Corte consideró que la lengua es uno de los más importantes elementos de identidad de un pueblo, precisamente porque garantiza la expresión, difusión y transmisión de su cultura. Y en el caso pueblos indígenas maya, cachiquel de Zumpango y otros versus Guatemala, la Corte, referida a la necesidad de que los pueblos indígenas puedan disponer de radios comunitarias para transmitir su idioma y su cultura, la Corte adujo que el ejercicio del derecho a la libertad de expresión a través de los medios de comunicación indígenas se realice individualmente por cada persona que emite una opinión o transmite una información, pero también y especialmente se manifiesta colectivamente debido a la particular forma de organización de las comunidades indígenas. En efecto, la dimensión colectiva de la libertad de expresión para los pueblos indígenas es fundamental para la realización de otros derechos colectivos. Es interesante ver de qué manera este cúmulo de derechos que se ha ido reconociendo y desarrollando a través de la jurisprudencia de la Corte, se ve reflejado en las reparaciones, es decir, en las obligaciones que los estados, que la Corte impone a los estados involucrados en aplicación de estos derechos. De acuerdo, teniendo en cuenta que hay una multiplicidad de reparaciones y que debe considerar los usos y costumbres de las comunidades que han presentado sus casos ante la Corte. En el caso Comunidad Mayagna, Sumo, Aguas Tigni versus Nicaragua, la Corte resolvió crear un mecanismo efectivo de delimitación, demarcación y titulación de las propiedades de las comunidades indígenas, acorde con el derecho consuetudinario, los valores y usos y costumbres de esta. En comunidad indígena Yaque-Axa versus Paraguay, se determinó que debían instituirse procedimientos adecuados en el marco del sistema jurídico nacional para procesar las reivindicaciones de tierras de los pueblos indígenas interesados. En comunidad moiguana versus Surinam, la Corte determinó que hasta que el derecho de propiedad de los miembros de la comunidad sobre sus territorios tradicionales fuese asegurado, el Estado debía abstenerse a realizar acciones, ya sea por parte de agentes estatales o de terceros que actúen con la aquiescencia o tolerancia del Estado, que afectaran la existencia, valor, uso y goce de la propiedad ubicada en el área geográfica donde vivieron tradicionalmente los miembros de la comunidad. En comunidad indígena Yaque-Axa versus Paraguay, la Corte estableció como reparación delimitar, demarcar, titular y entregar las tierras. Se determinó que el Estado deberá identificar este territorio tradicional y entregarlo de manera gratuita a la comunidad Yaque-Axa en un plazo máximo de 3 años a partir de la notificación de la sentencia. Y si el territorio se encuentra en manos privadas, la Corte, el Estado debe proceder a la expropiación de ese territorio para entregárselo a la comunidad. El masacre de Plan de Sánchez versus Guatemala, la Corte determinó que el Estado debía desarrollar programas de estudio y difusión de la cultura maya achí en las comunidades afectadas a través de la Academia de Lenguas Mayas de Guatemala u otra organización similar. En comunidad moiguana versus Surinam, se estableció como reparación la creación de un fondo de desarrollo destinado a programas de salud, vivienda y educación de los miembros de la comunidad. En comunidad indígena Yaque-Axa versus Paraguay, la Corte determinó que mientras los miembros de la comunidad se encontraran sin tierras, el Estado debía suministrarles los bienes y servicios necesarios básicos para su subsistencia. Se puede decir en conclusión que la Corte ha desarrollado una amplia jurisprudencia para el reconocimiento de los derechos individuales y colectivos de los pueblos indígenas. Sus estándares en relación a los pueblos indígenas constituyen un importante elenco de soluciones que pueden informar las demandas de otros pueblos de la región, tanto a nivel regional como nacional. Y a su vez, a través de las medidas de reparación, la Corte ha dado una orientación a las políticas públicas para que en un Estado democrático de derecho pluralista y participativo se incorpore la diversidad cultural y se vuelvan multiétnicos estos Estados, porque es una necesidad que exige la propia dignidad humana que está en juego en cada caso donde hay involucrados derechos humanos. En conjunto con los pronunciamientos de otros órganos del sistema, se ha conformado un importante corpus juris o cuerpo jurídico para el avance de los derechos de los pueblos indígenas de la región. Por supuesto, queda un gran camino por recorrer y una situación que es tanto estructural como histórica, que requiere de cambios, pronunciamientos y soluciones también estructurales. La Corte es un tribunal de puertas abiertas, continúa trabajando para brindar soluciones dignas a las principales necesidades de la región y en este sentido siempre se encuentra a total disposición de dialogar, encontrar soluciones justas y tejer lazos con el fin de encontrar nuevas iniciativas que conduzcan a la necesaria y urgente concreción y realización de los derechos humanos de los pueblos indígenas y tribales. No quiero terminar estas palabras sin realizar una reflexión final, en el sentido de que cuál es el deber y la obligación de los jueces nacionales frente a demandas como en este caso los pueblos indígenas y tribales. Todos sabemos que los pueblos indígenas y tribales se encuentran sometidos a ataques que provienen básicamente de quienes, a veces con protección de los estados, avanzan sobre sus territorios a través de la deforestación, de la explotación de los recursos naturales y a través de desplazamientos de estos pueblos hacia lugares donde no se puede mantener su tradición de vida, no se puede mantener su cosmogonía de la forma en desarrollarse como seres humanos. Los jueces nacionales, yo he sido juez nacional durante más de 30 años, tenemos la obligación, por la vía de la aplicación del control de convencionalidad, de aplicar no solo nuestro orden jurídico interno, los principios constitucionales, los principios legislativos, sino también de aplicar justamente estos estándares que el sistema internacional de protección de los derechos humanos ha ido desarrollando. Los estándares que la Corte Interamericana y el Sistema Universal van desarrollando a lo largo del tiempo respecto de la protección de los pueblos indígenas y tribales constituyen un elemento imprescindible a ser considerado e integrado en la decisión de todo juez nacional cuando se trata de derechos humanos de los pueblos indígenas. Esta visión de una autonomía, de una independencia, de una total autodeterminación, de la posibilidad de optar por un sistema de propiedad distinto al tradicional o al occidental, de que sus derechos sean realmente contemplados, de la obligación de una consulta previa antes de cualquier afectación de derechos al territorio de las comunidades, nos parece que es esencial porque hoy hay que reconocer, vuelvo a repetir, la sobreexplotación de los territorios, a veces el afincamiento dentro de los territorios del crimen organizado, haga que cada vez sea más imprescindible un sistema judicial que esté atento, que pueda reaccionar en tiempo real frente a estos problemas, constituyéndose en la valla más importante para evitar la violación a los derechos humanos. La Corte ha sostenido, y yo soy un convencido de eso, que el juez nacional es el primer y más oportuno garante de los derechos humanos de las personas. Cuando el sistema internacional de protección de los derechos debe proteger, es porque el juez nacional ha fracasado en la protección de esos derechos. Entonces, mi mensaje de cierre es justamente, y aprovechando este ámbito en el cual el Superior Tribunal de Justicia ha creado la oportunidad de debatir estos temas, señalar y reforzar mi solidaridad con los jueces nacionales para desarrollar esta tarea tan, pero tan importante a favor de los pueblos indígenas y tribales, en el caso concreto de este seminario, y a favor de los derechos humanos en general. Muchísimas gracias.
Agradeço ao Dr. Ricardo Manrique por esta abrangente exposição a respeito das decisões da Corte Interamericana de Direitos Humanos sobre os direitos dos povos originários. Indago aos meus companheiros de mesa, a Chay Suruí, o cacique Bira e a Wanawá, se gostariam de fazer alguma consideração.
Boa tarde, mais uma vez, né? Eu queria, na verdade, fazer uma pergunta para vocês dois, né? A gente sabe, né, da importância desses instrumentos como a OIT 169, né, para salvaguardar os nossos direitos, né? Então, como por exemplo, né, agora em Rondônia, no meu estado, a gente tem o povo arara, né, que está numa briga, agora eles conseguiram, né, para serem incluídos nos estudos de impacto da hidrelétrica de Tabajara, que inclusive vai impactar um território que é um território de indígena isolado, né, que está em isolamento voluntário, que é o terra indígena Massaco. Ou seja, se esse indígena, né, não pode ter o seu protocolo, porque ele tem que ser respeitado a situação de isolamento voluntário, né? Ou seja, a resposta já é não para esse protocolo, isso não vem sendo respeitado. Além disso, né, a gente...
Must say no to the protocol. In fact, this is something I learned in the last days, and correct me if I'm mistaken, because I haven't graduated yet and I am still learning. But I learned that these protocols need to be reviewed every 10 years. And now, after the last COP, the one before last, actually COP26, where the issue of the carbon market was closed or defined, what we are seeing now in our territories is the carbon cowboys shooting in our territories. And in order for us to have a carbon market in our territories, we do need to have that protocol first. We need to have protocols and life plans, and not just in these cases, but also in cases of this intrusion, such as what's happening in the Yanomami land, because that generates a lot of impact for us as well. Now, I spoke about the carbon cowboys, and what I see is that those protocols are not being respected, or they're not conducted correctly. I think I heard a little bit about that from my prior colleague, is how can the superior, or to the Supreme Court, guarantee that not just the case law of the Supreme Courts, but also international agreements such as ILO 169 can actually be ensured that they are implemented so that our rights are ensured? That is my question. Thank you. Thank you. Now, Dr. Carlos Manrique.
Justamente lo que se acaba de plantear tiene que ver con problemas tiene que ver con los problemas. Hola.
¿Sí?
¿Me escuchan? ¿Me
Sí.
escuchan? Bueno, justamente lo que aquí se ha planteado va en línea con lo que yo traté de explicar. Es decir, hay problemas y demandas que los pueblos indígenas y tribales tienen permanentemente en cuanto sus derechos se ven afectados, y justamente tiene que haber una respuesta, un acceso a la justicia de manera adecuada para que esas demandas puedan ser resueltas aplicando los estándares, vuelvo a repetir, de la Constitución de Brasil en este caso, y de la Convención Americana y demás instrumentos de protección de los pueblos indígenas. Muchas gracias.
Muito obrigado. Realmente há de existir uma constante atenção para a obediência às normas, tanto as normas internas como as internacionais, e uma constante provocação aos órgãos encarregados de aplicar na prática essa proteção, né? E acredito que, inclusive, eventos como este têm o objetivo de promover essa conscientização dessa necessidade, que não dispensa a constante vigilância para que estes protocolos e essas normas sejam constantemente obedecidos.
And rules are constantly obeyed. There is no doubt that that is essential. Would you like to add, sir? Yes, good afternoon, everyone. I would just like to thank Minister Paulo Sérgio Domingues for having invited us here, and Minister Herman Benjamin, who invited us to be here, to be part of this journey, to be with you. I'm very happy to have been present in these last two panels. Our tribe lives in the forest, working to preserve nature. to preserve our forests, our territories, and our lives. It's a big challenge. So it makes me happy when I have a chance to come to these seminars to see the Brazilian Supreme Court bringing this debate about indigenous peoples and the environment to the forefront. And I also heard from Dr. Ricardo, president of the Inter-American Court of Human Rights. Because his words strengthen us. It increases our self-esteem. It energizes us to continue because we are not isolated in the midst of the forest anymore, alone. Because there are courts, an Inter-American court, this house, the Brazilian court, bringing a debate like this one makes us proud and gives us strength to believe in a Brazil and humankind that is fair, without violence, protecting nature, and its true guardians, which are us, indigenous peoples. Thank you very much. I would like to thank you, Chief. And yes, in fact, for us, it's a great pleasure. And it's important to recall that this is the court of citizenship. The citizenship belongs to all Brazilians, to each and every one without exception. And that's how it should be. I would like to thank Dr. Manrique for its exposition and my colleagues at the panel. And with that, I declare this panel closed. We will stop now for 15 minutes and move on to the next panel.
Organizar as contas é tão mais fácil com Minhas Finanças. Como eles pensaram nisso? Como que a gente pode dar mais ferramentas para quem tá lá usando o app do bebê?
Já sei. E se desse para organizar os gastos por categorias? Tipo, gastos com pizza?
Isso! E ainda ver os extratos de todos os bancos num só lugar.
Genial!
A gente criou o Minhas Finanças para você descobrir como é fácil organizar sua vida. Descubra o Minhas Finanças no app do bebê.
A cultura é capaz de transformar vidas. É prática que ecoa cidadania, inclusão, democracia. É potência criativa que faz pensar, agir e se orgulhar. A cultura é motor que faz crescer a economia e fortalecer o social. É espelho de um Brasil vivo e diverso. É manifestação que não se pode deixar de alimentar. É com essa convicção e ciente de que cultura também é um direito constitucional que o governo federal lança o Decreto de Fomento à Cultura, que vai garantir maior eficiência na gestão cultural. A partir de agora, o fomento será adaptado à lógica dos projetos culturais, ganhando maior eficiência e transparência na administração dos recursos públicos, o que é bom para os artistas e agentes, para a gestão governamental e para os brasileiros que têm garantido seu direito à cultura. Uma iniciativa que vai apoiar e valorizar a cultura e a arte brasileiras, com mais democratização, descentralização e diversidade, fazendo com que as leis Rouanet, Paulo Gustavo e Aldir Blanc contribuam cada vez mais para o resgate dos nossos valores e da nossa identidade. É o reconhecimento para quem trabalha e vive pela arte, ajudando a fazer um país melhor. Brasil, União e Reconstrução. Governo Federal.
Organizar as contas é tão mais fácil com minhas finanças.
Com Bira, com a Tchai e com a Tayara e com o meu amigo Herman Benjamin. Benjamin, eu quero te cumprimentar por esse evento.
Benjamin, I would like to congratulate you for this event, because particularly this last panel, which is almost the closing panel, brings life to this panel. You bring life to this panel. When we hold events like this one, and I see there my colleague Sergio Boquina, we break the ice in the court, and we bring feelings, beliefs, emotion, ideas, life in the end, which is what motivates art, the aesthetic expression of this creative activity. So your initiative, and I see here in the coordination, scientific organization, the work and the relationships that you have with indigenous peoples and with the environment, photography, art. We're very proud of this. So I'm very grateful of being able to participate, albeit briefly, in view of the activity that I perform at the Internal Affairs Office, but I'm very grateful of being able to participate and to see that the Superior Court of Justice is receiving this debate. Once again, I repeat, breaking the rigidity of the court and bringing to us life in this very important, very, very important moment, very rich moment for us. As the moderator of this panel, I have to say that the photographer Sebastião Salgado is a legend. I did my best to research for this panel, and I looked at the books I had at home, and also I looked at the books that we receive here in the office, and Sebastião Salgado is renowned internationally. He has received basically all the awards that exist in arts and photography. He is recognized not just for his photographs, but also for his books. Books in which he investigates foremost the matter of the poor population, excluded populations. And he has done wonderful work helping people, humanitarian aid. He is really a very unique human being. In addition to being a great talent, a writer, he is also a person who does good, who changes the world around him. I didn't know, but he holds a master's and doctorate degree in economics. And he worked in the area for quite a while before being embraced, as he says himself, by photography, and before his talent was recognized. Suffice it to say that he holds the #1 chair reserved to photography in the renowned Academy of Arts of France. So we as Brazilians are very proud to have a citizen of Minas Gerais recognized for his talent by that academy. In this very brief introduction, I remembered that I need to speak about our panel, Justice and Art in Indigenous Affairs. When I went to the Museum of the Vatican for the first time, I saw right at the entry a sculpture that dates from approximately 140 before Christ. Many of you may have known that statue because it marked an epoch. It's a statue of Lau Ponte, where you see 2 children being strangulated by a serpent. That sculpture comes from an image of the Trojan War and Virgil. Virgil reproduced it in the Aeneid. And then represented it in the statue. It was represented in the statue by Laoconte. And the statue of the children and the serpent was found in 1004, divided in 3 or 4 pieces. It had been damaged. It went to the Vatican Museum, which already existed at the time, and never left it. And the interesting thing about the statue, in view of its beauty and the way in which it was sculpted in the year 140 BC, it started to be reproduced. When people began speaking about the Renaissance, it started to be reproduced and served as a water divider in the talent of the Renaissance artists that exploded in painter and arts and sculpture. But it was copied by several artists of the Renaissance and gave rise to many others in the modern era of sculpture that started with the Renaissance. So what is art? Which is our panel, especially indigenous art. With the law 11645, the national official curriculum of the primary and secondary education of Brazil, indigenous culture was included in the curriculum, and this reveals a large variety of objects with different types of aesthetic approaches and with a great number of different materials, which shows that art is present in the daily lives of indigenous peoples, bringing beauty, functionality, and a sensitive vision of the world. The U.S. anthropologist Ruth Benedict stated that culture is like a lens through which man sees the world. Tracing a parallel, the art that is created through the lens of a photographer that registers the culture of autochthonous peoples makes it possible to raise the veil that often covers the lack of ability of some to see what is different, thereby helping them understand their way of lives and not accepting prejudice and the disrespect to the human rights of those peoples. There's no doubt that art contributes for that humanist view to be taken into account by judges when they examine litigations that involve indigenous peoples, whether by single people, collective demands, calling attention to their relationship to the world in which they are inserted, plants, animals, and the genuine right in preserving this inestimable environmental heritage. And with those brief words, I would like to introduce our speaker, Sebastião Salgado, renewing my feeling of honor in receiving him in this panel. Thank you very much. It is difficult for a photographer to have a structured discourse. It is really not a photographer's specialty. A photographer speaks of a way of living, an experience. I have an enormous pleasure in speaking to you here today because more and more the judiciary has appeared to us who fight within the environmental movement, the indigenous movement, as an ally, our greatest ally in this terrible moment that we have just gone through with a completely predator government, with the three powers, one of the branches of power was the one that was really by our side, and that is the judiciary power. Minister Herman has always been by our side and invited me and Lelia to come. So of course we came. Of course we accepted holding this exposition here. Why? Because here it has a multiplying effect. If I am able to, through our pictures, ensure that some judges, some prosecutors are motivated to fight for the indigenous cause, we will win so much. Because the power of a judge, the power of a prosecutor is limitless. I was born in the countryside. I remember my city of Minas Gerais, a small town actually in which the power was in the hands of a judge and of the prosecutor. So I was a small boy and I watched and I saw that the police chief had a gun and that he had power. The politicians, the mayor had power. They appeared only once in a while, but they had power. However, when something needed to be solved, it was either the judge or the prosecutor who did it. And together, nobody could go against them. Nobody could refrain them. And in the Amazon, with the conflicts that we have, if we have by our side the prosecutor and the judge, we will have half of the victory in our hands. So it is extremely important for all artists to come to you. Why? Because it is necessary. I'm going to speak to you now of a creative process. That's why I was invited to come here today to speak about art, about the art of photographing, about how I organize myself, how I work. But I have to speak about this. I am forced to, because there is no type of art or creative movement that is dissociated from the community to which it belongs. Lelia and I taught for a long time, 15 years, in the greatest photography school of Japan. And we went to Tokyo once a year. And with a group of students of the last year of that school, we identified the boys and girls that were true photographers. Of 30, there were 2 or 3, and we told them, now you have to stop photographing. You cannot stop photographing, actually, because there's a special, you are special because photography is inside you, and not everyone can do this. And to be a photographer, you have to have a tremendous pleasure in being with people and being close to them. Very few people have that. You have to feel comfortable at the moment of taking your images, at the moment of being part of a community, which becomes your home. Very few people have that. But when we saw those boys and girls that had that ability, we said, in fact, we said, you're going to have to stop now because you're going to have to go to university. You're going to stop for a while, and for 2 or 3 years, you have to go to university and take courses in sociology, anthropology, geopolitics, economic history. You have to learn, you have to take certain subjects that are going to make you understand society, the society to which you belong, because it is only then that your work will have a special sense. So whenever we start a creative activity, we need to have a greater motivation. I worked in the Amazon. I spent 7 years there. I traveled to the Amazon 58 times. These were trips in which I spent 3 or 4 months in a single place, a little less than others. But I spent almost 7 years in a row in the Amazon. Of course, there are great specialists on specific aspects of the Amazon, but to know the Amazon as I know it, well. There are very few people who do. I know the Amazon were up close. I went there and I lived with Bira. I lived in his house. We went into the jungle. We went to the sacred villages. We went everywhere taking pictures of everyone, and everyone was so connected to my lens, to my way of work, because I had a concept, a work concept. And it is this soul of the process, of the creative process, that needs to be there to create. You need to define what you are going to do. And this can only be done well if it is something that is deep inside your heart. You need to love deeply. Why? Because for 7 years, I photographed the Amazon, but I had already done so much before. And the set of pictures of the Amazon probably covers 9 years that I spent in the Amazon. Now, for you to do that, you need to have a deep love for what you're going to do. Otherwise, you won't be able to hold on. Those of us who are used to a wonderful apartment like we have in Paris and an intellectual life like we have in Paris, to go to the jungle and sleep in a hammock, having to look beside the hammock with a light at night to see if there's not a spider or a serpent beneath it. And if you have to go to the jungle and dig a hole to do your needs because there's no other way, and working very close with indigenous peoples, well, I had to have armed guards from Funai with me to go to the jungle because there are wild animals there and it's dangerous. So you're sitting there in the middle of the jungle trying to do your things, but you have to have guards because there are native pumas that can get you if you're not careful. And there are so many things that are dangerous. You really need to love the jungles, and indigenous peoples were born there. They have all the antibodies that they need. And I learned from experience that I don't have antibodies for a special little bug called pium that work in the light. And these very difficult little bugs, pium, once filled my body with sores until little by little I created antibodies against pium. And now they can sting me and they will do nothing. But you have to love this. And I was there to resist, and I resisted these little piums. And in the trips that I do to the Amazon, that I did, when I conceived the work that I was going to do, I conceived it all. I knew that I was going to have to photograph the airborne rivers, the river system of the Amazon, that I was going to photograph the indigenous communities traveling by boat, that I would have to do everything. And I had to imagine this. I had to imagine how I was going to do this. I had to organize things in my head. I knew that I would have to do aerial photographs. So I contacted a consultant. I got in contact with somebody who was used to flying above the Amazon to see how I could organize my mind for my imaginary to work, to take pictures of the Amazon from the air, to see how I was going to be able to conceptualize the project that I was going to experience for years. I had to come to Brasilia so many times, sleeping at my house, at the house of my friend Jorge Viana, and going to Funai to receive authorization to enter indigenous lands. I had to go there and convince the technicians of Funai of my work, convince them that my work would bring a return to the indigenous movement. But it took a while for me to convince them. And then I had to choose where I was going to work, because I had already defined something that took me months to do, convincing the guys from Funai, and they sent someone from Funai to the tribe because I had to receive authorization from the tribe. Without that, it would not be possible for me to go. And once they authorized my trip, I had to organize my expedition. It was a true expedition because Funai forbids us from eating the food that indigenous peoples eat. We don't have the right to. We have to take everything we eat. I had to take 2 jungle captains who know how to hunt, who know how to fish, who know the jungle. Do you remember when I got there with Agustin and with Bebe? Bebe is a great fisher. He lives in Tabatinga. He is half indigenous. He is a half caste. And he was a soldier of the Forest Battalion, which is the best battalion in the planet in terms of military jungle operations, and Brazil has that. And for many years, he was a soldier in this Brazilian RB battalion. But today, I hire Bebe to go with me on my trips, and he is the greatest fisherman in the world. And we worked with the Corubu, the recently contact indigenous group that lives alongside a very important river where fishery is very important. Fishing is very important. But Corubas are not indigenous people from the rivers. They are from the inside of the jungle. So we went there with Bebe, and Bebe fished enough fish to feed all the Coru for a week. Because what they do is smoke the fish. They don't eat them immediately. So he caught tucunare, huge tucunare, and pirarucu of 150 kilos in a single night. So Bebe, everyone fell in love with him. And the day before we had to leave, I had with me journalist Leon Serba. And together with him, we produced the biggest publication ever of the indigenous movement in Brazil. The newspaper Folha de São Paulo gave me the cover with 10 pages done by Leon, and Leon interviewed the last day before we left. He interviewed the leader of the Corubu and asked him, "Give me your message, whatever message you want, and I will present it to the government of Brazil. The president is from São Paulo and he will read your request. So just ask whatever you want and I will write it." And so we thought he was going to have a huge social request asking about the big problem of protecting indigenous lands. And he thought and thought and thought and said, "Well, ask your chief to give us Bebe as a present." Because his real life is practical. It's what matters are practical things. So we lived incredible things, but I had to take Bebe. I had to take food. I had to take a cook to jungle captains. I had to take a translator, an interpreter, and we had to reach there by canoe. That means 4 or 5 canoers that we had to select. We had to select by hand very carefully because indigenous peoples go around naked. Beautiful girls you can't imagine. And I was responsible for all of them. To avoid any type of sexual violence, I was responsible for them. So I had to select people very, very carefully. So going there was not easy. I had to stop in the village closest to the indigenous villages, buy everything that I needed, absolutely. Rice and beans, spices, sardines, everything we needed to take everything. Because indigenous people live in a balance that is at the limit. They live in a certain place for a certain number of years, and when food becomes scarce, they have to leave. Ecosystems have a very weak, fragile balance. So when food becomes scarce, they leave. They go to another place, and they only return on average 150 years later. After that forest that they actually don't have anymore, they were forced to go and start farming, but they come back to that same place only 150 years later. When the lands are fertile again, they have a wonderful knowledge of agriculture. And so as I said, we had to take all our food because we did not have the right to eat their food. So it's not easy to prepare everything to receive an authorization to do these things. So when I offer an exposition. For example, at the Sesc Museum in Rio de Janeiro, an exposition with 205 photographs, in addition to 2 projections of 110 photographs each, totaling 420 or 30 photographs. Can you imagine that when I materialize one picture, when I press the button, in 1/40th of a second, the shutter closes and I take a picture. So it's a fraction of a second. I need to be very smart to capture an image. Otherwise, I lose it. But I'll explain more about that later. I'll explain to you why I don't lose it. But it's really fractions of a second. It's 1/250 of a second. So if you multiply that by 400 pictures that I took, I have maximum 2 seconds of pictures altogether that represent all the things I picture. But for those seconds, I gave my life, years of traveling, such a long time dedicated to that little tiny decisive moment to materialize a picture. Sometimes you look at my pictures like you saw here in my exposition, and I think, well, Salgado just went there, clicked the button, and he has a great eye, and he was able to compose all this. But it's not easy. It's very difficult, my friends. We go to a village. I went to Bira. I had broken my knee. My knee was huge. And Bira prayed on top of my knee. Indigenous peoples placed compresses on my knee, but my knee was broken. And when I got to the city, they had to operate me. They gave me a mechanical knee, but I couldn't just leave because I had created an expedition and it was all there. And all I had was that authorization. There was no other. I had to stay. So what I did was find a stick and drag my leg throughout the jungle because my knee didn't fit in a pair of pants, so I had to do without it. And the truth is that photographing is a way of life. It's a way of life. I have a body prepared for work. I may be the photographer that worked the most in the entire world. I've been photographing for over 50 years. I'm pretty old. I'm almost 80 now. So really, photography is so special. I actually started clicking the button of the camera when I was doing my doctoral photography in Paris. I was 26 or 27 years old when I took my first picture. But in truth, I started taking pictures when I was a boy. As I told you, I was born in a farm in the Mata Atlântica, the Atlantic rainforest. When the rainforest was being opened for farmers to set up rural properties, that was a policy, breaking down forests. And my father had a farm. He didn't like to ride horses. We had a big farm in Minas Gerais, and he loved walking. And right before the rain started, my dad used to take me to the highest point in the farm. Farms in Minas Gerais usually have elevations, so that I could see the rains arrive. And it was the most beautiful thing in the world to see those clouds loaded with rain. Sometimes the wind blew, and we saw the sun and those successive mountains. And I saw from above the most beautiful thing that I could ever have seen, and it was there that I formed my visual universe. You can put 100 photographers in one same place, and you will have 100 different pictures because each one of them brings within them a visual heritage that is different from any other. So at the moment that you intervene with your complete visual heritage, with your ideological heritage, with your heritage of life, of relationships, things that shape your personality. And in that representative cut, everything is there. And I actually work a lot against the light. I didn't know I did that. Leila set up an exhibition in Havana, and I was photographing sugarcane and tobacco in Cuba. And one Saturday, I went to Havana to see this exposition, and I saw a teacher from the School of Arts who took students to see my photography. And I went to see what he was saying. And the teacher said, well, this photographer, everything he does against the light. And I said, well, that's right. He's right. I didn't know that. So I started thinking, why do I take my pictures against the light? Well, my mother was born in Switzerland. My father in Galicia. And I was very light-skinned, and when I went in the sun as a child, I got hurt, and my mother forced me to wear a hat, and I had to stay in the shadow. So everything for me came from the light to the shadow. So I learned how to look against the light. So my pictures, I'm sorry to tell you, but they have an incredible relief that not all of them have, because they're basically all against the light. And when you picture against the light, you create volume, a volume of lines, of separations, of planes. And it's difficult. But I learned how to expose my films. I learned how to do everything so that my pictures have that volume. So photography is something else. Sometimes I have an exposition. Today, I gain my living selling pictures to collectors because my pictures have become objects, quote unquote, of art. And why am I saying this? I forgot.
You were saying something about photographing against light, says someone in the audience. Yeah, I seem to have forgotten what I was saying, but anyway, it's the jet lag, it's the age. I work every day at 3 o'clock in the morning, so at this time of day, I tend to be pretty tired. Still, the fact of the matter is that when you have, as is the case, a series of photography, the series reflects one's life, and the process of photographing itself is a very interesting project, or a very interesting process. I used to photograph with cameras and films. Today I use a high-quality digital camera, a digital one. And I used to have a serious concentration problem, because when you get out there to do your photographs, you have to be totally connected, totally in tune and in sync with what you have before you and what you will photograph, to the point that by the time you finish your task, you have to lie on the floor because your whole body is so tired. So it is a very immersive task in that sense. So in that photography process, I had a break in my concentration, because whenever the film would, come to the end in the camera, I had to stop and change it. And that would be disastrous, because I was totally concentrated. And all of a sudden, the film would come to the end. I had to rewind it and get another one, replace it. And so I solved the problem by singing. I take my photographs singing. I sing every time. And I used to sing pretty well up until 2010. I actually got this virus in 2010 that killed most of the, say, nerval connections in my body or on my face. So some of my face nerves are partly distorted. But anyway, I still sing, not as well as I used to sing anymore. But when I sing, I am so connected to the music, and when the film would come to the end, I would be able to continue and rewind the film and replace it, and I was totally concentrated in the tasks because of music, because I was singing. Whereas today with digital cameras, I don't need to change, the SIM cards or memory cards anymore. I can spend up to, 3-4 days with one same memory card. 1,000 plus photographs can be taken with a memory card. And when you sing, you actually end up enchanting the people around you. They become so delighted to have you around them. And I remember working with Bira in his tribal village. I was totally immersed and totally connected with everyone else. I was theirs and they were mine. And when someone approaches you to get their portrait, I mean, the relationship between the person in the portrait and the photographer, the person who has been photographed and the photographer, is so deep because it really reflects or illustrates a moment of dedication that you're giving to the person. And people recognize it. I remember working in Bosnia, in the former Yugoslavia, that terrible war that took place there. I went out to photograph a train that was actually a refugee camp, a very cruel train, the most cruel I had ever seen in my life, because everyone was apparently entitled to flee to Germany because the chain of ruthlessness was being applied to them. Some of them were refugees, some of them were allowed in or out, but before ruthlessness came to them, they were not recognized because they had not been the subject of violence. So they were not entitled to leave or go anywhere, and they would be accumulated or concentrated in old train wagons that would come from Germany and which were no longer in use, but which were placed there, and those wagons were changed into homes and people would, live there, packed, but still they had a home. And there I was, taking my photographs, and there was this lady, and I went about and took the photographs. At a point in time I stopped, and she came and she hugged me and she cried so much while hugging me. And I could see that she was so happy because finally someone came to her, looked at her and paid attention to her and gave her what she needed. She actually just needed a little bit of attention, a little bit of affection, a little bit of music. So photography has and involves all of this process. You must conceptualize your work. You must dedicate yourself to it. You must love what you're doing. And you must place your life at the service of photography. Photography is a way of life. People often tell me in exhibitions, Salgado, you are an artist. And I tell them, I'm not. I am a photographer. And being a photographer is a very special privilege. A very special privilege. I know about more than 130 countries. I really know these countries in depth, getting there, getting out there, getting to know people, getting to know the places. Who else can do that? No one but photographers. I remember talking about in northern Ethiopia, left this small little town called Lalibela and went all the way up to the Siamese Park, 100+ kilometers walking on foot on the mountains in Ethiopia, no roads, 4,200 meters above sea level, and clouds above our crowds hovering over our heads. And I got to know that place like the palm of my life, of my hand, and walking through paths that have been used for thousands of years, carved by people's foot and by the paws of animals that have been going and coming for thousands of years. And I discovered something fabulous. I found out that that fertile land that was the cradle of the modern civilization of humans, the Egyptian civilization. Why is it that the Egyptians had a fertile land? Well, the land was fertile because of the deposited humus on the banks of the Nile, where Egypt established itself as a country and as a fully fledged civilization at the time. I found out where that land came from. It came from the largest tributary of the Blue Nile, the Tekeze River in the Ethiopian mountains. No one had ever gone through that area, except for the Ethiopians themselves. I was the first Western man who set foot and walked about that region. It was a fabulous experience. I could see all of those erosions around me on the mountains. Many of you may probably have gone to the Grand Canyon in the United States. It was very much like the Grand Canyon, or even bigger, those colossal erosions that the land, with its millions and billions of years behind it, the land was carried over by the Tekeze River and forwarded that matter to the Blue River, and the Blue River received that deposit of blue land around it, which made it so fertile. I mean, that is so enormous. It's such a pleasure to be able to experience that firsthand. And we got to those villages where the Ethiopian are Christians, Coptic Christians, the very first Christians. And I remember coming to this village, we were lost, and we had organized this expedition, 22 men, about 30 donkeys, and half of the cargo was really food for the donkeys, because after a given point in time, there's no more food for the donkeys. So we had to take food for the donkeys so that they could carry our load and finish the trip. The kitchen would leave early in the morning, and they would walk past us about 10 o'clock in the morning, and we would meet them again later in the evening, because they would by then have already set up camp. And I remember we got lost once, myself plus two persons. One was the guide, and the other was the person in charge of my photography materials. So we got lost, and we got to this one village at about 2 o'clock in the afternoon, and we were extremely tired. And we were met by two ladies, and there they were at the top of a small mountain, as if asleep. And then we were met by these two ladies with two vessels. They untied our boots, they washed our feet, and they dried up our feet and kissed our feet, the very symbol, the very gesture of Christian humbleness. And I felt as if I were in the time tunnel at the very beginning of Christianity. Photography is such a huge experience. And while working in the Amazonian region, the Amazon was something that I had felt that I had the responsibility, the ethical and the moral responsibility, and also a national responsibility as a Brazilian citizen to cover. All of the projects, all of the photography projects I have been involved in have all been in one way or another linked to my life. I prepared a book on the world of labor. I served and was an economist. I was a Marxist-Leninist economist, a left-wing economist, and person. Of course, labor, by definition, is the most important portion of a production function. A production function is about labor, technology, and capital. I studied mathematical economics and changed that into a secondary education equation, or second degree equation. And labor was always the most important factor, because labor was actually what produced the two other variables, because capital is the appropriation of a portion of one's labor, and product, of course, is what is created. But then again, the worker doesn't get back in his or her wage all of the value, because part of that value is appropriated by the owner of the farm, the owner of the plantation fields. But that's how, of course, the owner can survive or live, by appropriating for himself part of the worker's value. And that establishes capital. And what is technology? Well, consider what a robot can do. A robot does precisely the movement that man's hand has always done to set up or assemble pieces or parts in an assembly line. So robots have just replaced men in the tasks that were carried out by men. So technology, is the very source of labor and work. So technology is certainly the most important portion. In the mid-1980s, we were really going through a fully fledged second industrial revolution. Intelligent or smart machines found their way to assembly lines, production lines, computers, bots. So at that point in time, I decided to portray the so-called traditional workers before they would vanish before our eyes, and they have vanished. In the past, a car factory would be called a car factory, a car maker. You would, of course, manufacture the engine and the outer protection, whereas everything today is made up or set up in an assembly line. People just get together to assemble the car. So I decided to pay tribute to the world of labor before traditional workers would disappear before our eyes. So in the mid-1980s, we changed the production processes. We shifted. There was a paradigm shift. So there I went. I went out in the 1980s and I photographed the whole world. I photographed in 25 different countries because I wanted to document the end of the first major industrial revolution. The result was a book titled Workers in Archaeology of the Industrial Age, a very successful book, which was published at a point in time when we were just beginning to talk about globalization. It became a reference book on globalization. It was the beginning of my recognition as a photographer. And by taking those photographs, I realized that there was yet another revolution going on in this country. When I was a child, and also when I studied economics, 90% of the Brazilian population were in the countryside, rural population, whereas today more than 90% of the Brazilian population is urban in nature. It was that industrial process that was shifted or transferred from the wealthy countries that dismantled the production system they had in place at the time, polluting and heavy industries which were exported to us, China, Brazil, Indonesia, the largest country that are as vast as the continent, and with a substantial population, meaning cheap labor. And so these industries set up their business here, and that led to a massive urbanization process here in Brazil, in India, in China, and everywhere. And by photographing workers, I realized that there was yet another major revolution going on in the world, which was the reorganization of the human family. On average, we had 200 million people abandoning the countryside and migrating to the cities. We were going through the end of the Cold War in Europe, meaning the geopolitical destabilization of the world was going on. And as a result, a huge number of economic and political refugees and war refugees that came into being. So after I finished that series, I decided to cover yet another series on the reorganization of the human family, which led to this huge book called Migrations. And exhibitions followed all over the world. It was a huge success. And by photographing those migration waves, I had to work in the former Yugoslavia. And the experience was very violent. You can't imagine. I had to work in Rwanda. I saw genocide going on in Rwanda. I saw 15 to 20,000 people being killed every day in villages where the populations were concentrated. It was no longer even possible to bury people. I mean, you would see around you a bulldozer, dig a big hole into the ground and with that shovel, 50, 60 dead people would be, dragged on into the hole and heads and arms left behind. I mean, such a violent situation, such violent scenes. I went ill. I got ill. I got sick as a result. And at the end of my work, I was being attacked by my own staphylococcus. I had about 10 wounds under my arm. I had huge wounds between my testicles and my anus. I could barely walk. Tremendous suffering. I had sex relations or sexual intercourse with Lelia, and no sperm would come out, but only blood. I said, my prostate is dead. I saw the doctor and he said, no, Sebastian, your prostate is good. But what's happening is that you're dying because you see so much death, so much violence around you that you are yourself dying. You have to stop, otherwise you will die. You're really absorbing all of that into your body. And I told myself, my God, what am I going to do? So we made a decision. We decided to stop. We rent a house in Trancoso along the coastline in Bahia. And my head was going bad, really. I was ashamed of being a human being. I abandoned photography. I did not want to photograph anything else because I used to photograph nothing but human beings. And that was when my parents became old. They had a farm in Minas Gerais, and I'm the only male child in a family of 11 or 8. And my children, my fathers decided to donate the land as a legacy to myself and to Lélia. And we made a decision to become rural. owners of that land. We gave up photography, abandoned photography, decided to move to Minas Gerais and began to live on that farm. That land, which used to be so fertile and wonderful when I was a child and had more than 60% of Atlantic forest coverage, had nothing else to it. Because to make this modern, urban, fantastic Brazil we have today, we left behind an ecological desert as a result. So my father or my parents' farm was desert. And not only their farm, but everyone else's farm in the region. And we saw that such a sick land, such a deadly land, just as I was sickly. And Lelia told me, Sebastian, you said you were born in a paradise because that's what it was when I was born. You know, there were jaguars, animals, wild animals, fauna, wildlife, birds, and the rivers where we would swim with alligators. Wonderful, beautiful place. And Lelia told me, why don't replant the forest that was here before? Why not? Well, that's an idea, I told her. Sounds like an idea. We were not ecologists. We had no concern whatsoever in terms of the environment or ecology, but we went ahead and decided to replant the forest on that farm, because by replanting the local trees, if we were able to gather their seeds, they would certainly thrive. We had no idea that we would be able to ensure a return of biodiversity by planting, and that's the only way of ensuring a return of biodiversity, by planting the local species, because biodiversity is always local. And then we started to replant the trees, and the forest began to blossom and come back. Of course, we had the problems. We lost a lot in year one, but we overcame the problems. I already had some reputation in photography, and we were able to secure funds from all over the world. And to solve the problem in our space, we had to plant 2,500 trees. A lot of money was required. I'm just a photographer, and I'm not rich. Lele is just a designer herself, a graphical designer. But then we got some money. Today we have a little more than 2,500,000 trees totally planted. So the project went on and was fully implemented. At the very beginning, it was so good to see, you know, how much good was being made to the world. A tree, even if small, is itself a tree. It already yields leaves, fruits, and the insects start coming back, and biodiversity comes back as a result. And there I was, I could see nature coming back before my eyes. I could see the land that was previously dead regaining life before my eyes, and life began to come back to me as a result. And after 1.5 years or so, I wanted to go back to photography. So we then designed or conceptualized this one project, one of which translated or as a result into a book called Genesis. And we decided to give ourselves a gift. We wanted to travel the planet and see firsthand the sad parts of the planet. Is it about time to wrap up my talk? I suppose so. But anyway, we decided to design this photography project. And that was when I decided to go about and establish the project. I visited the headquarters of Human Heritage in Paris and also Conservation International. Conservation CI opened up their files or archives to me, and I found something wonderful. I found out that almost 48% of the planet remains as it was on day one of creation, Genesis. We've managed to destroy virtually 50%, but a very high altitude portions of the planet we have not. And the same is true for the Amazon. And the extremely cold portions of the planet, such as the Antarctic or portions of the Arctic, are still there untouched and pristine. The boreal forest or the northern forest is pretty much there, almost untouched. The large deserts have not been very substantially destroyed. So with Leila, we were able to prepare this project to travel the planet for about 8 years, seeking out these parts and geographies throughout the planet. And that was the result of a creative effort where we would work 8 months every year photographing. So I would go out 2 months covering a story and come back to Paris for a few more months, and Lelia would, set up this whole structure, and she's tremendously capable of organizing everything you may imagine. She's extremely precise in what she does. And my team would prepare everything, would set up, or would set the arrangements, would come back to Paris. So on average, I was able to cover 4 2-month-long stories every year. And I would spend 4 months doing nothing. But then again, I wasn't really far from my family because Leila would come with me in most of these stories. She wouldn't spend, 2 months, but 15 days. Sometimes she would come at the beginning, in the middle, or at the end. And in all of these travels throughout the Amazonian region, except for a few only, she would come with me because, of course, she has her tremendous creative contribution to the work, but to do the whole work, she has to come and live the experience firsthand so that she too can be in a position to create. And I traveled the planet for these 8 years. And taking pictures, photographing. Of course, I could not possibly fail to come to the Amazon region. I worked with several different tribes because it was part of this pristine world. And while working in the Amazon region, I realized that it was no longer the Amazon I had photographed back in the 1980s. The outskirts of the Amazonian region, the outskirts were where destruction started, from the outer edges. The outer edges were way in vis-a-vis what it used to be back in the 1980s. So I decided to come and cover the Amazon, and the photography work in the Amazon region emanated from, or derived from, the Genesis project. So every project has actually derived from the previous project, one from the other. And as I look back in hindsight, people may say, hey, Salgado, I think you are the most intelligent person in the world in terms of organizing your work. I mean, your work has enjoyed great reputation, recognition, and return. I say not at all. I was just blessed with the privilege of attending university and getting training, academic training in macroeconomy, national accounts, and public finance, what we used to describe as political economics at the time. So I was exposed firsthand to these very concepts of society because I am part and parcel of it. And my work has always been connected with the historic times I have lived through. So that's why it made sense, because it was totally consistent. I would read 4 daily newspapers every day. I do read extensively, and I got information. I had access to information. I tell young people, a university illustrates the history of humankind, while at the university you get a compact version of the history of humankind. You get training and professional development opportunities. So it's absolutely ideal to get proper training if you get a chance to go to the university, because after that you do not necessarily have to do what you studied. Like myself, for example, I studied economics, but I did not work as an economist, but that provided me with a foundation, and that, I believe, is the most important element in one's training and formation. The Amazon project derived from the Genesis project, the previous Genesis project. I felt I had this moral, ethical, national obligation to do these photographs because I was extremely pleased to get acquainted with and familiar with the indigenous communities, because they are the sweetest, the most docile people you may ever come into contact with. I was saying yesterday at the opening session, there is no aggressiveness. I mean, listen to what Bira says, listen to what you say. No aggressiveness at all, but rather it is a pro-integration narrative. We try to explain to people that life is much more than just material consumption. In society, we focus so much on consumption. We live in isolation, and we live in a rather sad, aggressive manner, and assets or goods are just material goods for us, nothing else. But then again, bear in mind, we are ultimately an animal that has lived in community for more than 70,000 years. Of course, human beings were there before, but the fact is that we've been living in community for the past 75,000 years, roughly. So the fact is that in an indigenous community, within the indigenous community, there is a huge sense of solidarity. And we tend to think that indigenous people are all alike and the same. They're not. There are more than 180 different groups of indigenous peoples in the Amazonian forest, 180 different cultures. In the Xingu area or tribe itself, you know, Bira, how many tribes are there in the Xingu area? 16 different tribes, right? Roughly, yes, I think, yes, 16 different tribes living in the Xingu area, 16 different languages. There are people in the Xingu area of Tupi-Guarani origin and background, and there are also other people there in the same area that are of Caribbean origin and background. Yet others come from the Andes Mountains or the Andean Mountains, and yet other people or groups come from Central America and have flocked to that area for thousands of years. And the fact is that each of them has their own culture. And the most aggressive ones I have seen are precisely those that have been most attacked by those from outside of the forest. They are the ones who were the subject of aggression and violence, and they learned violence with people from outside, but they themselves are unable to do any evil, thing bad. There are tribes in the Amazonian region that will not eat animal flesh if it contains warm blood, because they think and understand that warm blood animals make them become aggressive. They only eat flesh or meat from cold blood animals such as fish, snakes, etc., because aggressiveness is the very last thing in their scale of values. And they're such sweet people, extremely sweet and docile people. I think we in Brazil have this special privilege of being able to live side by side with the prehistory of humankind. In the Brazilian Amazonian forest, you have 102 groups. These are pre-contact groups. And it's really amazing, outstanding. And it's us, you know, we are there too, because they are part of the same species of Homo sapiens that left East Africa thousands of years ago, when it went down to southern Africa and walked towards Europe, and then walked towards Asia, and then walked on towards Australia. The same Homo sapiens that entered Australia 140,000 years, and or in the past 21,000 years, Homo sapiens came to the Americas. And it's us, ourselves. I mean, those who left Eastern Africa and walked on to Europe got here only 500,000 years ago. And those who went through Asia got here about 20,000 years ago. But when they met themselves here, when the Portuguese came here and had sexual intercourse with the indigenous women, they had children, because biologically and mathematically speaking, we are one and the same species. So to me, the greatest richness I've ever experienced in my life was the fact that I was able to come to these communities, in which I thought would be an extremely difficult situation. And when I got there, I found out that everything that was essential to me was also essential for them. The love is the same that they have for their women, the same love I have towards my wife, and the love that each indigenous father has towards their children is the same love I have towards my children. The sense of solidarity I have in my and with my community is the same solidarity they have among themselves. They are us, and we are one in the same species. There is no difference whatsoever. There's one difference, however, and that is the fact that they have chosen isolation, and they have chosen to remain distant from this rather odd and strange society we have become. We have become aliens. We have pretty much moved away from our planet. I mean, if you live in Brasilia, you don't live in Brazil, you live in Brasilia. If you live in Rio de Janeiro, you don't live in Brazil, you live in Rio. If you live in Beijing, you don't live in China, you live in Beijing. These are capsules. We don't seem able to live on planet Earth. The only difference between us and the indigenous people lies on our foot. Our feet are sick because we stick our feet into these shoes and they smash our fingers, or toes rather. We have our thin and long feet, whereas the indigenous people have triangle-like feet, just as is the case of the feet of the Papua New Guinea indigenous people, because the indigenous people use their toes and they're able to climb a tree like a monkey, and they never fall down from the tree. And I remember when I am about to cross a precarious rundown bridge, I get the indigenous people to carry my photography equipment because they'll never let it fall down. And the only difference is that we have spoiled our feet, whereas they have kept their feet untouched. and natural in shape. So not only did I travel to the Amazon region, but also I was able to develop this body of work in the Amazon region. And I have also enjoyed the privilege of experiencing firsthand the prehistory of my species and becoming acquainted with what I was, I as a human being 1,000 years ago. And I was able to see firsthand how evolution has taken place. And from a human perspective, there has been no evolution whatsoever. We have just isolated ourselves in different groups. And unfortunately, if there is a catastrophe on the planet today, we in the cities will not survive, but those who are in the forest, they're the ones who will survive because we are unable to hunt and fish. And if we experience shortage of water and electricity in cities, many people will die. Many people among us will die. And if we have 3 overlapping syndromes, such as COVID, for example, our species will disappear. If the Yellowstone National Park volcano erupts, which is highly likely, we will be deprived of electricity on planet Earth for more than 2,000 to 3,000 years, until such time as the dust is released onto the atmosphere and vanish away. But very possibly the human species will survive in the hinterlands, in the heartland of the forests, through the communities that are able to and know how to live with nature. So yes, it has been a wonderful experience, and it's been a great pleasure. And the fact is that my work in the Amazon region was just really a continuity, a continuum of my whole life as a photographer, permanently learning. Thank you so much. I'll leave it there.
Uma exposição tocante, marcante, humana, sensível.
This has been such a humane, sensitive, and wonderful presentation. There is so much for us to learn that goes much beyond matters of art and justice and all of the engagement that this brings with it. Thank you very much for having shared with us your journey, your success, which allowed us to travel with you to each of your stops and to follow your creative process. For us, as I said at the beginning, this has been a spectacular opportunity to gain life and humanity. We have truly recovered thanks to your exposition. Thank you very much. I would like to register here the presence of our Vice President, Minister Augie Fernandes. It's a great pleasure to have him here. Minister Suzette, also a great pleasure to have her here. I had already registered the participation of our colleague Joaquina, and we also had with us another minister of the House. And I would like to thank all of you who were here with us today. And as I told photographer Sebastião Salgado, and as he said, photography is a way of life. And for him and his wife that conducted their travels through the Amazon, we are grateful, and we are observing from close up everything you do. I'd just like to thank our President, Minister Luis Felipe Salomão, and then President Maria Teresa, who should reach us any moment. She is participating in a doctoral thesis presentation in São Paulo. And I have to say that there's no coincidence that Minister Salomão is presiding this session, as he said very well, of an almost closure of the role of the National Justice Inspector. And I was so happy to give this role over to him, because we certainly have a much better Justice Inspector than we would otherwise have with him. And then if I were to be the justice inspector, but for family reasons, I could not take this office, and I know that the alternative was Mr. Solomon, so I'm happy that it was him. So we have with us here Minister Augie Fernandes, the National Federal Justice Minister, and Mr. Augie Fernandes as well. And we judges, I say judges because we ministers are also judges, we care more about the justice inspectors than about the presidents of the courts. People seem to not understand this, but I see Judge Edivaldo saying that, yes, that's what it is. President of the court is the president of the court, okay, but the justice inspector, the national justice inspector, it's different. So the role of these two colleagues is absolutely essential so that these very important issues addressed by the judiciary court, by Brazil, and by civilization are treated appropriately by the judges in terms of access to justice, of organization, and of how these issues are addressed. And that's where optimism comes, Sebastião, from the fact that we not just have the president of the Superior Court of Justice and of the Supreme Court of Brazil, but also the two national justice inspectors directly involved here with this subject. And each of the ministers of STJ, Minister Suzete Magalhães, for instance, who was the president of the Regional Superior Court at the regional level, which is probably the regional Supreme Court with the biggest territory in the world. It includes so many states, Goiás, Bahia, until recently Minas Gerais, and others, so it's a huge size. And we also have a tremendous experience accumulated in Minister Suzete Magalhães that she brings to the jurisdiction of the Supreme Court. And then we go to another region of Brazil, the other side, not the Amazon, but Paraná. And there we have Minister Suquino, representing the public ministry. Minister Suzete Magalhães. So for us, it is essential for these issues to be debated here in the House, as Mr. Solomon said. That's why we appreciate the initiative of Minister Maria Teresa so greatly. I know that when we speak about the environment and indigenous peoples, you always think that I'm the one who organized these things. But in this case, the idea wasn't mine. It was Minister Maria Teresa's idea, and her team organized this wonderful event. So at this time, I would like to pay tribute, not just to the two national justice inspectors who are here, my colleagues, but especially to that magnificent team of the Superior Court of Justice, to the interpreters. Thank you. Thank you. To our interpreters and to the diplomatic corps. I see ambassadors, the ambassador of Norway, the ambassador of New Zealand, of Canada. Okay, sorry, Barbados, of course, Trinidad, Tobago. So the diplomatic corps is with us here as well, because this is a subject that is global, truly global. And finally, it is important, Sebastião, for you and Lélia to take from us more than we received from you, which is going to be difficult, because we received not just knowledge and art, but STJ, starting from now, starting last night, and through initiative of our President Maria Teresa, the depositary of the greatest collection in a public entity, because of course there are private collections of the works of Sebastião Salgado, which are now part of our assets. So a round of applause to him. And with that, I return the floor to Minister Salomão, and we will now move on to our closing session. And as a last message to Indigenous peoples, I have to tell you that this event was for you, and we, ministers, feel deeply happy that you have actually taken over the Supreme Court of Justice. There was no panel in which Indigenous representatives were not the majority, in addition to being represented, because this event had to have the voice of those who are protected by the Constitution and by the law and by international law. So, Minister Salomão, thank you very much. Thank you for your work. And we leave here with a lot of hope in relation to your initiatives, which will come. One of them in the week of the environment. I'm not going to advance anything. I cannot. But in the week of the environment, Minister Salomão will be spearheading a very important initiative in relation to deforestation in the Amazon. So I give you the floor, Minister Salomão. Thank you, Benjamin. It's no use for you to try to escape your responsibility. The scientific coordination is yours. Now, of course, Minister Maria Teresa, our president, gave her full support. But we already know that this touch of humanity, this touch that brings with it, as I said at the beginning, that brings life to these walls, to this very difficult function of ours, the duty of judging. It falls on us and on all justice operators to have this moment in which we stop to reflect on the subject of art and justice and indigenous affairs and everything it involves. As Sebastião said, and he spoke with such passion, with such involvement, and we feel as though we were part of all of the travels he mentioned, so it's a privilege for us to be here. So let's close this panel. We have already extended it too long, so I will leave you all to move on to the closure. Thank you to all of you who have stayed until now.
Senhor embaixador e o senhor...
Madam Ambassador and ambassadors at large, please kindly join us on the dais up here.
Senhoras e senhores,
Ladies and gentlemen, joining us for this closing session, we'd like to acknowledge the following guests. Second Vice President of the Federal Senate, Senator Rodrigo Cunha, representing the President of the Federal Senate, Mr. Rodrigo Pacheco, as well as the Chairperson of the Participatory Legislation Commission, Congressman José Silva, representing the Speaker of the House, Congressman Arthur Lira. As moderator, Superior Court of Justice, Justice Assuete Magalhães. As speakers, the Vice President of the Superior Court of Justice and of the Federal Council of Justice, Justice Fernandes, as well as speakers, His Excellency the Ambassador of Canada, Emmanuel Kamarianakis, the Ambassador of New Zealand, Mr. Richard Redengars, and the Ambassador of Norway, Odd Magnum Root. Senator Cunha has the floor. First of all, good evening, one and all. I wish to greet our moderator, Justice Assuete Magalhães with the Superior Court of Justice. Greetings likewise to Justice Og Fernandes, Vice President of the Superior Court of Justice. Ambassadors, Emmanuel Kamarianakis, Ambassador of Canada to Brasilia, Ambassador Richard Prendergast, Ambassador of New Zealand, Mr. Odd Magni Rude, Ambassador of Norway, and my colleague, Congressman José Silva. First of all, on behalf of the Federal Senate, I wish to thank you for the opportunity to attend such an important event, an event which I am sure is ultimately aimed at deepening our knowledge on such a sensitive and necessary topic, which should always have been discussed as it regards or involves the indigenous causes, and do so at an international level. The little time I have spent here in person in this event has allowed me to enjoy the presentation by photographer Salgado, really a lesson on love for art and love for our land and for the earth and love for life. 40-50 minutes that allowed me to certainly walk out of this event much better than when I first walked in. On behalf of the Federal Senate, I am here representing President Pacheco. He just traveled to London earlier today, and I have a short, brief speech prepared by our team, which clearly underscores the need for us to engage in a broader dialogue, as well as our view as a Senate. Brazil has advanced progressive provisions regarding the rights of indigenous people in the domestic legal framework, but we have not yet materialized them, not as much as we should anyway. Historically, the indigenous peoples of Brazil have been denied their right to expression, and their rights have been the subject of an indigenous affairs bureaucratic policy. The major injustices in our history have been perpetrated against them, and there has been a major lack of opportunities for indigenous peoples to take part in public life. The 1988 Federal Constitution brought some relief in terms of their legal rights, ideally speaking. However, that is not enough. We must do more than just listing rights. We must act accordingly. Have we made any progress? Quite certainly. Yes, we have made progress. And that today, political peoples have a level of representativeness in Congress, in the judiciary, as well as in the academic circles. Representatives of indigenous peoples have taken on a high-profile role in the international scene, given the strength and legitimacy of their struggles. And it has been the same in the National Senate. Indigenous affairs have been repeatedly being the subject of our deliberations, especially as regards the inspection efforts conducted by the legislative, including public hearing, subject matter expert committees, and other initiatives. More recently, we have focused our efforts on the Yanomami peoples, and the humanitarian tragedy that has taken place in the Yanomami territory is the first-hand direct result of what I mentioned earlier, the fact that indigenous voices have been silenced. It is also a point of convergence of several problems experienced by the Brazilian state apparatus, i.e. organized crime, predatory exploration or exploitation of the environment, and indifference in education, and the preposterous situation of the healthcare system. This is more serious, even more serious among indigenous peoples. A revolutionary effort must be undertaken based on active listening and respect to or for traditional cultures. Hence the importance of this international symposium, which is aimed at not only hearing, but also ensuring that we interconnect the three different branches of power, the judiciary, the executive, and the legislative branches of power, and especially establish connections among lawmakers and those who advocate the indigenous causes. At the Senate, we have established the Provisional Commission on the Status of the Yanomami, an inherently political committee which is aimed at following up and monitoring firsthand on-site the removal of gold panners or illegal miners from the Yanomami territory while proposing solutions to the conflicts going on out on the ground. The committee has worked by means of members of the Senate and staff members, and we have held regular meetings. We have also planned and held hearings with representatives of the executive branch of power and the different ministries and quasi-government organizations such as the Environmental Protection Agency, health agencies, the Ministry for Indigenous Affairs, among other players. And that is the kind of work model we should all follow. Ladies and gentlemen, the role performed by the Brazilian state apparatus regarding the indigenous peoples must recognize their cultural specificities or peculiarity, as well as the pressure they have been under, including territorial, societal, demographic, market pressures. Quite often, the situation seems to be counter-majority, and hence the perception that is so usual in certain circles that indigenous people enjoy, or indigenous peoples enjoy a lot of privileges, but that couldn't be farther away from the truth, because indigenous peoples have put to a test the constitutional notion that this is a democratic rule of law. A real democracy is by definition plural and will respect the rights of minorities. It cannot be the dictatorship of a majority. We must make progress in enforcing the norms established and enshrined in the Constitution. Cooperation among the different branches of power is absolutely key. The Senate remains committed to being a body that will acknowledge and value the Brazilian traditional peoples. And with these remarks, may I again extend my thanks and congratulations to all of the organizers of the event, everyone who has worked so tirelessly to bring the event to fruition, and all of the judges in this Supreme Court or Superior Court. And of course, I remain available for further initiatives and joint effort with the Senate. Thank you. Federal, or rather member of the Federal House of Representatives now has the floor, Mr. José Silva. Yes, good evening, one and all. My initial remarks, of course, couldn't possibly be but to thank you all on my behalf, and also, of course, on behalf of the Speaker of the House, Congressman Arthur Lira. May I extend my greetings to Justice Magalhães, Judge or Justice Og Fernandes, as well as Ambassadors Emmanuel, the Ambassador of Canada, Ambassador Richard from New Zealand, as well as Ambassador Og Magne from Norway. And I do so representing and do so on behalf of the Senate, President Cunha. It is an honor really for me as someone who has come from the state of Minas Gerais, as a rural extensionist who has worked with agrarian reform and related issues. It's such a pleasure to hear our colleague and country fellowman, Sebastião Salgado, discuss his professional and personal journey, and particularly to Judge or Justice Assuete. May I say a few words on behalf of our commission, a very emblematic commission, not only in terms of the Brazilian democracy, but more importantly, a participatory form of democracy. While in my first term in office, I said in the past that the commission is the voice, especially the voice of the minorities in the Brazilian Senate. In that committee, we interact with more than 1,000 different institutions representing CSO or civil society organizations, such as associations, trade unions, cooperatives of several different walks of life in society. And the committee is precisely where, at the Senate, challenges and the pains experienced by the Brazilian population are given a voice, and we are able to translate that into legitimate proposals and pieces of legislation at a house where more than 18,000 bills of law are being examined. And for those of us, members of Congress, who defend the minorities, especially in an international event such as this today, I was only able to attend the last panel session, photographer Sebastião, a panel session where we saw just how generous nature is, but just how strongly it can react when we are not insightful enough to understand signs given by nature. And this is how I have succeeded in changing an executive order, serving as rapporteur, the executive order on land grabbing, because it was aimed at changing the constitutionally established time limit for the demarcation of indigenous lands, especially for those who did not meet the original requirements. In one of its articles, the executive order would ensure that the lands of traditional populations, former runaway slave communities and indigenous communities would be regularized. I was able to introduce an amendment, and it's being passed by the House, and Senators Pacheco and Rodrigo Cunha will certainly be responsible and careful enough to ensure that land regularization not be conducted to the benefit of third parties, nor that it will somehow deprive the indigenous nations and populations from their rights, nor the traditional and riverine populations. I have also been able to discuss Justice Magalhães in different climate conferences about the issues involved in the Amazon region. It is not enough to just demarcate territories and go about land regularization. More than that, we need to ensure proper environmental regularization. And for that to happen, a third leg of this tripod-like proposal that we're currently discussing at the Participatory Democracy Commission is about technical assistance in a constructive perspective, while respecting science and, of course, respecting the local knowledge and building on their knowledge to foster more knowledge, while respecting the history and traditions of these communities. Only by so doing, as we believe, will we be able to enjoy the certainty that Brazil will be able to fulfill its role regarding our original peoples, and also fulfill our responsibility as a nation as regards preservation of the environment and also preservation of the cultures and traditional populations, the indigenous populations as well, of course. So these are the brief remarks I'd like to share with you, and I would also like to thank you for the opportunity given to the Federal Senate, together with my colleague from the other house of the Congress, to be here and listen to you, while of course keeping our doors wide open to any input to be forwarded by civil society organizations to make sure our participatory democracy translates into pieces of legislation to help overcome the pains and the challenges experienced by the Brazilian population. Thank you very much.
We now give the floor to Madam Minister Suzete Magalhães. Good evening, ladies and gentlemen. I would like to start by greeting the members of this closing panel of the International Symposium. Minister Og Fernandes, Vice President of Superior Court of Justice, Ambassador of Canada, Emmanuel Kamarianakis, the Ambassador of New Zealand, Richard Prendergast, and the Ambassador of Norway, Dr. Magni Ruth, with whom I have the honor of dividing this debate panel. I would also like to greet very especially Senator Cunha and Deputy Da Silva, who have demonstrated that our parliament is not indifferent to the necessary fight in favor of the rights of indigenous peoples in our land. I would also like to greet Minister Benjamin and Minister Kukina, whom are here today, and magistrates of first and second level, members of the public ministry, public defenders, ladies, ambassadors, other authorities present here. And I would especially like to great photographer Sebastião Salgado, who made it possible for art and law to come together to defend the rights of indigenous peoples in Brazil and also to defend our environment. I would like to greet the civil servants and all those who have been here with us in this in-person event or online. I would like to start by greeting Minister Maria Teresa de Assis Moura, President of the Superior Court of Justice, who with and secure hands has been guiding the destiny of the court and its citizens. I would also like to greet Judge Frederico Mendes Jr., President of IMD and partner institution, and most particularly Minister Benjamin, notorious magistrate, scientific coordinator of the Symposium. That opens a floor for debate and discussion about the affirmation of the rights of indigenous peoples, amongst others, launching an approach with an institutional bias. As we all know, the rights of indigenous peoples are consolidated in important international instruments, especially Convention 169 of the ILO that was incorporated amongst us by a decree of 2004 that established in its Article 16 that the peoples that we address should not be transferred from their lands. Also, we need to call attention to the UN Declaration and American Declaration on the Rights of Indigenous Peoples. These international instruments include various provisions that ensure the rights of indigenous to their lands, so that any restrictions to those rights by the Brazilian state would represent an affront or an offense to the international law of human rights and would eventually lead to penalties at the international level. Making sure these instruments are obeyed is an obligation of the state, which must also ensure the tenure of the lands of indigenous peoples and protect these lands against the invasion by third parties. In fact, most recently, the Convention, the Inter-American Convention of Human Rights, whose president was here this afternoon, declared Brazil to be responsible for the violation of the principle as reasonable duration of a process in the judicial discussion on the collective property of the land, and imposed on Brazil the payment of $1,000 in favor of the community Chucuru. Well, in Brazil, we all know that the legal framework for the protection of indigenous rights suffered various retrocessions in the last decades. At the formal level, I must say, we all know that a lot of progress was made in the terms of a plural, participatory, and inclusive concept that recognizes the plurality of indigenous peoples. And the same happened in terms of the health of indigenous peoples. We know that the right to health, especially before the Constitution of 1988, was seen as an existentialist right and an individual right. But after the Constitution, it was ensured as a fundamental right and as a collective one. I'd like to mention a recent judgment by the Second Court of Justice, of which I'm a part, and Mr. Augie Fernandez also participated in that judgment, because he participated in that court until recently. And at the time, the STJ defined that the public ministry should defend the indigenous rights of a father of indigenous child that, because of a lack of health care provision, passed away. The court understood that the public ministry did not have the legitimacy to pay this compensation for moral and collective damages. Very well. So they decided that the second court of the Supreme Court decided against that, decided that they did have the duty to do so. Because of the progress made in the constitutional arena, particularly after the Constitution of 1988, it is important to note that indigenous movements in all continents starting in 2004 brought with them advancements in this area as well. The Brazilian law, after the Constitution of 1934, our Constitution ensures the right of indigenous peoples over their lands. This is a right that remained in all subsequent constitutions, the Constitution of 1937, 1946, and of 1967. The last one of 1988, in addition to ensuring the fundamental rights of human beings, dedicates a whole chapter and 2 articles to the rights of indigenous peoples, recognizing their social organization, their customs, their beliefs, and their traditions, and reaffirms the secular right of these peoples over the lands that they traditionally occupy. The federal constitution compels the Union to demarcate indigenous lands and to protect them. And to conclude this international symposium, we will have in this last panel an exposition by Minister Olga Fernandes and by the 3 ambassadors that I introduced. Minister Olga Fernandes, who will speak first, is a lawyer by the Federal University of Pernambuco and also graduated. He's the Minister of Justice since 2008, and today is the General Coordinator of Brazilian Justice, but before he was part of the Electoral Court in 2018 until 2020, and he today is part of the Special Court, the Superior Court of Justice. Before, he was part of the second court of that area, but he judged conflicts that have to do with indigenous rights before. He is currently Vice President of the Superior Court of Justice and of the Federal Council of Justice, and also the National Justice Inspector at the federal level. So that is a summary of his curriculum that shows that he is very much prepared to speak about this subject. You have the floor, Minister Olga Fernandes. Good evening, ladies and gentlemen. I would like to start by greeting the president of this panel, Minister Suzete Magalhães. Justice, actually, Suzete Magalhães, who has been with us here at the Superior Court of Justice for a long time. I'd also like to greet Ambassador Emmanuel Kamarianakis. Please excuse me if I pronounce it wrong. I can see that he's an ambassador because he said I did it very well. So the ambassador of Canada and the ambassador of New Zealand, Richard Prendergast, the ambassador of Norway, Mr. Odd Hoot. Is it Odd? No, it's Odd. Senator Rodrigo Cunha, the second Vice President of the Federal Senate, and Deputy José Silva, President of the Participatory Legislation Committee. Sebastião Salgado was around here, and he's here. There he is. I see him. So I'm greeting him with my heart. I know time is running short, but I have to say that his presentation was the one that moved me most than all the ones I ever heard and brought me such humanity. And I cannot but thank him very much. So dear colleagues, dear colleagues of STJ, I see Minister Kina, the always present Minister Benjamin, who is here and there and everywhere, our dear guests and participants at this event. I don't have a speech. After what I saw here today, I have to start by telling everyone to forget the CV that my dear colleague Association shared about me. Here before you is the 5th generation of an indigenous person that until today exists in Águas Melas in the Agreste region of Pernambuco. 5 generations back, I would have been an Indian. I am. It's in my blood. I have Indian blood. With this miscegenation of the races, that is so Brazilian. I added a Portuguese blood, black blood, and that is where I come from this great mix. After what I saw today, I have no legal considerations to make, but I will speak about the experience of somebody who was in his 70s and had the experience, not such an extensive experience as our dear Salgado, of course, but that had a chance to know something of the world. And because I learned something of the world in this brief passage, with an indigenous peoples, this is a story that I have already portrayed in a short story that is called Galinha Preta, or Black Hen. In an indigenous community, there was a discussion among 2 men in the village, and one of them sought out the chief, shaman, the big guy, to report to whom they thought was the judge of their ethnicity what was happening. So one said, well, I am having a conflict with my neighbor and I want this to stop. What should I do? And the shaman said, well, this is what you should do. Take a black hen, kill it, and put it close to where he lives. And that was done. And can you believe that the neighbor died that night? In one of those tragic coincidences that life offers. And having died, justice was achieved. So that community held a judgment, a formal judgment in relation to that death, and concluded that in fact, that person had died a natural death that there was nothing to punish. And so that person went to the shaman again, and he said, no, I cannot accept that version of justice. I don't accept it. I was here with you, and you said for me to do what you said, to kill a black hen, and I did so, and the guy died. So I am responsible for his death, and I want to respond for my acts. So that position of common justice or formal justice has nothing to do with my culture or with what I think about the fact. And with that, the community sat down to discuss the situation. And the community understood that the man was responsible for the death of his neighbor, because according to the customs of the time and of the place, and that's not too long ago, the death had been caused by the situation that was created that led to the death of that citizen. The culture of that community determined that there was a responsibility to be determined in relation to someone who led to the death of his neighbor. So why am I telling you this story? Because in my trajectory through life, Salgado, you spoke about this so much wisely and scientifically, and that is the message that I want to leave, that we cannot violate the culture of other ethnicities, that this cannot be done. We need to preserve the customs just as they were created, as they matured, and as they are applied in a certain community, because the way we see things is biased. We see things in a way that can be criticized by them, just like we criticize the examples of colonization that Brazil suffered since 1500. Particularly from the Spanish in the continent, except for Brazil, and leading to great mortality. And thinking of, we have to think of everything that had to happen in South America so that that colonization could be processed, quote unquote, in our region. That is the message I have. That is my message. I am reaching this age of mine happy for having learned that we need to respect the understanding, the culture, the formality, the customs of these very ancient peoples. And we, who are the consequence of that mixture of races, have been here for a little less than 500 years. And we are here now, and we are greeting these other cultures that have been here for such a long time and that are being decimated, and that are being forced to assimilate a culture that does not concern them. So I'd like to conclude by recalling a message that I received, here from a very beautiful indigenous woman that sat beside me, Achai Surui, and that has to do with what we spoke about. Look at what was done with our population. She treats me as Your Excellency Minister Augie of Furio. We didn't put that there, so I'd ask you please to straighten that out, because including the tribe is backwards. It's pejorative. It isn't used anymore. We are peoples. We are ethnicities, indigenous nations, and we want to be recognized as such. That said, I'm grateful for your help, Chai Surui. So I'd ask you please to learn your lesson, and I did. Just like we don't treat people with disabilities archaically, by the inappropriate way that we did before, and I don't want to establish any comparisons, but we need to evolve. And evolution goes through recognition that we are not the last and only ones on this earth. So I finish with a sentence. So changing this reading from civilization to our civilization to the Chuchu, which have a phrase that seems to me very appropriate to close this event or my participation in it. Everything turns around power. Everything we did here has to do with power. Shushu said, power as a way of exercising a full dominion upon our similar human beings, or of including personal greatness, is justifiably considered bad, whether white or blonde or black. We ask you to stop being as bad as our culture has taught us. We need to change. That's it. That's all for today. Thank you very much.
Congratulations, Justice Fernandez. You have very aptly indicated that this is the fifth generation of indigenous people. And I believe that if we all look back in our family trees, we will probably find indigenous background among our forefathers or ancestors. And you shared an interesting case which very much speaks to the need for the Brazilian state to respect traditions, customs, and the beliefs of indigenous peoples. And that is precisely what the Federal Constitution has enshrined in Article 131. The Brazilian federal state under the 1988 Constitution does acknowledge the social or societal organization, the beliefs, the traditions of indigenous peoples, and their social organization as well. It is therefore necessary for the Brazilian state, through its congressional representatives, including those who are here with us in this event, it is necessary that you all continue to work to uphold the rights of indigenous people so that we can redeem this history of virtual decimation of these peoples who are at the very origin of Brazil as a nation. I'm saying that this is necessary in view of this message we have received by an indigenous lady who was here with us until a few minutes ago. It was forwarded to Justice Og. She says that in addition to ensuring indigenous peoples be able to enjoy their rights, it is necessary to ensure that they be respected, as very clearly indicated on this message or in this message. So thank you, Justice Og. We will now give the floor to the Canadian Ambassador, Emmanuel Camarinakis, the Canadian Ambassador to Brasilia. He has a degree from Calgary University, 1993, and joined the Canadian Foreign Service in 1993 as well, working from Ottawa. Mr. Kamarianakis has served as a foreign policy analyst and defense policy at the private office, including responsibility for Latin America and the Caribbean. He also served as Chief of Staff for the Vice Minister for International Trade from 2008 to 2010. He has served abroad in Mexico as Trade Counselor, as well as in Greek as Senior Trade Commissioner, and also in Iran as Third and Second Secretary for Trade Affairs, and also in Rome as Counselor Minister at the Canadian Embassy in Italy. He also served as Consul General of Canada in Dubai, and has also more recently served as Director General for Investment, Innovation and Education at the headquarters of the GC or GA Canada Global Affairs Canada. Ambassador Emmanuel Kamarinak very clearly shows in his professional career his ability and skill sets to talk about a topic that we all know. Of course, Canada also does experience some issues, just as we do in Brazil. And I must say that the Supreme Court Justice took part in a panel session earlier this afternoon with us, and she also shared her views and remarks on the ongoing struggles to uphold and advocate Indigenous rights in Canada. So with that introduction, Ambassador Manuel Kamarianakis, you have the floor. Before that, if I may, Madam President, together with the Vice President of the Senate, we will be launching the legislative agenda of the Brazilian Organization of Cooperatives, OCB. So we would like to apologize and take your leave, if we may. Yes, the brief time we have spent with you has been invaluable, and our advisors and staffers will be with you to the very end. And congratulations to all members of the Superior Court of Justice for addressing such an important matter in coordination with the other branches of power. Absolutely. Thank you so much. Those of us at the Superior Court of Justice would like to thank you both, gentlemen, for attending this event. Ambassador Emmanuel Kamarinak now has the floor. Thank you, Minister. Well, thank you, Justice. Good evening, everyone.
Bonsoir a tout le monde, un plaisir d'être ici avec vous. Cumprimento também nossos anfitriões, o STJ.
Greetings likewise to our hosts, STJ, Justice Fernandes, Justice Magalhães, and my dear colleagues and ambassadors attending this session, as well as, of course, the Indigenous peoples attending this event this evening. I also wish to congratulate those of you who were able to pronounce my name correctly. Not easy. I am happy to take part in this symposium, which addresses such an important matter for Brazil and for Canada as well, i.e. the recognition of the rights to which Indigenous peoples are entitled and the connection with justice. I'd like to congratulate the Superior Court of Justice for hosting an event that brings together Indigenous peoples and also the three different branches of power in Brazil with the purpose of engaging with and hearing Indigenous communities about justice. I'm also honored to take part in an event, or in this event, not only because the Supreme Court Justice Michelle O'Baswan has shared her experience regarding Indigenous reconciliation, but also because the matter is a top priority for Canada. Being here and be able to hear your experience regarding the protection of rights and justice is a source of inspiration. The experience, the challenges, and the priorities we have heard over the day and a half reminds me of the experience we have been pursuing as countries, Brazil and Canada. Canada also had a difficult experience, including or involving colonization and the Indigenous people. Colonialism was part and parcel of the efforts to build Canada as a nation from the very beginning. Indigenous peoples stood and withstood forcible displacement and destruction of their territories, disease, and the criminalization of their system of governance, their laws, their culture, and their spirituality. Our government has historically denied the rights of the First Nations, Métis and Inuit, and we use the following phrase in First Nations, which are the Indigenous people, Métis in Portuguese, I believe the word in Portuguese is mestiço, and of course the Inuits, the northernmost Indigenous communities. Our government has historically denied the rights of these three different groups by means of pro-assimilation practices and policies, including a system of residential schools, home schools between the 1900s and 1996, where indigenous peoples were forcibly or withdrawn from their families and assimilated in full-time home schools, many of whom, of course, suffered all forms of abuse. In 2007, abuse. In 2007, we began to implement an agreement to shut down these home schools by means of the Truth and Reconciliation Commission of Canada. The commission published its final report in 2015, including 94 calls for action, and established the National Center for Truth and Reconciliation. The Canadian government has undertook since 2016 to fundamentally change its relations with Indigenous peoples and do so based on recognition, respect, and cooperation as key guiding principles. That includes making progress towards recognition and the full materialization of Indigenous people. The foundation for this relationship focusing on flexible solutions that are to be co-developed based on their needs, priorities, and also the self-identified needs. Later, Canada incorporated the Declaration of the Rights of Indigenous Peoples into our national legislation, and we also need to ensure its full and effective implementation. This legislation provides Canada and the First Nations Inuit entities with a script for them first to work together to implement the declaration based on a long-lasting reconciliation effort. Under the law, Canada will speak in consultation and with cooperation or in cooperation with Indigenous peoples to take all necessary measures and make all necessary arrangements to ensure that Canadian legislation is consistent with the UN declaration, as well as, of course, ensure continuous and sustained efforts to uphold the rights of Indigenous peoples now and in the future, including respect for their self-determination and decision-making, as well as ultimate control on the matters that affect them, as well as countermeasures to hold the federal government accountable. Furthermore, the first National Day for Truth and Reconciliation was celebrated on September the 30th, 2021 in Canada. From now onwards, it will be celebrated every year. That day has been established as a public and formal recollection of the painful and continuous impact of these home schools in Canada for Indigenous and will remain a vital component of the ongoing reconciliation process. Also in 2021, the Honorable Mary Simon was appointed Governor General and head of the Canadian state and an Inuit Indigenous woman. She was also the first Inuit ambassador of Canada and has constantly advocated the rights of Indigenous peoples and has also been an active negotiator since 1995. We also know that there's so much more to be done ahead. Reconciliation is a long-lasting and difficult process, but it's also a necessary process. It is so good to see that Brazil is or has chosen the pathway towards reconciliation with Indigenous people that begins with respect, openness, and dialogue, as we have seen clearly in this symposium. This symposium is the forum for discussions and learning about the rights of Indigenous peoples and their future in Brazil and in other geographies worldwide. We have heard subject matter experts on Indigenous law and rights from Brazil, Canada, New Zealand, representatives of the young Indigenous movement, and also government representatives were gathered here today with the primary purpose of establishing ongoing dialogue towards the recognition of the rights of these peoples by themselves and also by the national institutions to the ultimate benefit of materializing their rights as a necessary continuity to the much needed reconciliation process currently underway. I hope to see even more contact among these groups by sharing best practices in the future as you continue in the path of reconciliation. In conclusion, may I say that a more peaceful and more prosperous world cannot possibly be reached without actual and significant involvement of the Indigenous people. Renewing our relations with Indigenous peoples requires innovation in our pursuit for partnerships and initiatives. This is a generation a generation-long transformative effort, and it requires all of us, and it begins with all of us in this room. Thank you very much. Congratulations, Emmanuel Cameronakis, on your remarks, which have very clearly shown that Canada, just as is the case in Brazil, Canada has also faced very much the same problems as regards the rights of indigenous peoples. And just as in Brazil, your remarks have shown that your country is working to restore and redeem this historic debt towards the indigenous peoples. The Canadian experience also provides evidence of the importance of international instruments that have consolidated the rights of indigenous peoples all over the world. You even mentioned, Ambassador, the United Nations Declaration on Indigenous Peoples. The UN Declaration has also been incorporated into or mainstreamed into the Brazilian domestic law. We have incorporated not only the United Nations Declaration, but also the American Declaration, the Inter-American Declaration on the Rights of Indigenous Peoples, and also the well-known and very important Convention 169 of the ILO, the International Labour Organization, which has served as a source of inspiration to the 1980 drafters of the Constitution as regards provisions on the defense and protection of the rights of indigenous peoples. Thank you so much, Ambassador. At this point, we will hear Ambassador Richard Prendergast, the Ambassador of New Zealand to Brasilia. He has worked in Brasilia since March 2022. New Zealand, as we know, has collaborated with Brazil in global trade flows and international security, as well as in sustainable economic development or growth. He has a master's degree in philosophy as well as international relations from Cambridge University, UK. He's also a career diplomat, has been since 2000 when he joined the Foreign Affairs and Trade Ministry of New Zealand. He has served in Washington, Banyan, and Afghanistan, as well as in Kuala Lumpur. And he also has a bachelor's degree with honors in international relations from Victoria University of Wellington. Also, as was the case with the Ambassador of Canada, the Chief Justice of the New Zealand Supreme Court also attended this event early this morning. So with that, Ambassador Prendergast has the floor.
Toko iwi, ko Richard Toko Inoa, na mihi. I just gave you a
Eu
traditional.
acabei de dizer para vocês uma saudação.
In that I talked about the land, where I come from, my ancestors, my family, and myself. I will give my remarks in Kiwi English today, but I will sprinkle them with Māori words and concepts to give you a flavour for that partnership. Let me first say a big thank you to Justice Benjamin for your great leadership. Thank you to my esteemed colleagues here on the panel. It really is a privilege to speak at this event, Indigenous People, Nature and Justice in Brazil. It weaves together three very important themes: Indigenous issues, nature and justice, that need to be discussed in an interconnected way as we talk about the past, present and the future. I would like to acknowledge the Indigenous people of Brazil, whose voices lead many important conversations, including through this event. Each of you represent your communities and tribes with such mana, a Māori concept that speaks to the intrinsic power of a person handed down from ancestors. It is a privilege to sit amongst the Indigenous Brazilian people here today. I'm a guest in your land. I extend my acknowledgements to all Indigenous tribes of Brazil who make me feel welcome as a guest in your country. As we heard from the New Zealand Chief Justice earlier today, Joe Williams, biculturalism is at the heart of our work in Aotearoa, New Zealand, the Māori name for my country, especially for people like me who have the privilege of representing our bicultural story offshore. While the relationship between Māori tribes and the New Zealand government remains ever evolving, including through a challenging colonial history, the past decades have seen meaningful, positive change in the law and in policy. Tikanga refers to protocols and customs, the things that we do, the way we do them. Underpinned by a living Māori concept, tikanga encompasses Māori law. Aotearoa New Zealand is increasingly implementing tikanga Māori into law in a way that reflects its ever-evolving nature. And this includes the mainstreaming of our founding document, the Treaty of Waitangi, the New Zealand Society. Another important concept, kaitiakitanga, a lived concept which refers to guardianship of the future descendants, is at the forefront of our thinking. And this has been conveyed by natural entities, and we're talking about nature today, being granted legal personhood status. In a Māori worldview, great natural features such as mountains, which I referred to in my opening, rivers and forests, are seen as our ancestors. Legal personhood status protects that nature as such, with all the rights, powers, duties of a legal person. Last year, Aotearoa New Zealand also celebrated our first Indigenous public holiday called Matariki. Matariki can be referred to as the Māori New Year, where the Matariki cluster of stars is clearly visible. Matariki is a time for reflection, including the cluster of stars who care for us and the ones that passed, time for family, and a time for the future. Celebrating Matariki on a national scale recognises the Māori worldview of the lunar calendar and acknowledges our country's recognition of Māori knowledge. Our Aotearoa New Zealand Minister of Foreign Affairs, Nānia Mahuta, is the first Māori woman to hold the position. Through the minister's term, she has discussed and exemplified a value-based approach to our foreign policy and diplomacy. These values and core concepts are principles from Māori culture, such as my favourite, manakitanga, which Brazilians show to me every day: kindness, respect, and goodwill. Another concept, whānaugatanga, talks about relationships. Kotiakitanga, working together, and the aforementioned kaitiangatanga, guardianship of our natural environment. These are the lived values of Aotearoa New Zealand that we use in our foreign policy, our diplomacy, and our trade policy, which is a trade for all agenda. I have spoken how Aotearoa New Zealand as a nation has seen change in the law and policy and in values as the result of a partnership between Māori and the New Zealand government, implementing Māori customs, knowledge, and voices. Many of these sentiments I've shared, such as protocols and relationships, which do living things of the environment, are just representations to name a few, but will be identifiable for the people I speak to who are Indigenous to their lands also. While we all have specific colonial histories and settler histories that have been talked about today, there's also much shared feeling between Indigenous communities globally, so much shared insights into and views of the world, between the Māori of Aotearoa New Zealand, the native tribes of Brazil, the First Nations people of Canada, and the First Nations people of Norway. We are all communities around the world who are Indigenous to their lands. In our increasingly global community, we must make the opportunities to create Indigenous to Indigenous connections, to understand Indigenous issues, how they relate to nature and justice, and how our past and present will inform our future. Tēnā koutou, tēnā koutou, tēnā koutou katoa. Obrigado.
Eu cumprimento o embaixador Richard.
I would like to thank Ambassador Richard Pendergast for his very important contributions showing that in New Zealand, as in Brazil and also in Canada, we all have problems that we share, problems that require for the social milieu to bring Indigenous peoples and autochthonous people to society, respecting their beliefs and their traditions. His Excellency show that in New Zealand, as in Brazil, there is a woman minister that is a ministry of the federal government, and he also showed the need of respecting the beliefs of Aboriginal peoples, as Minister Olga Fernandes did before him. So I'd like to thank him for his presentation and thank him also for his very interesting concepts that he presented. We will now give the floor to the Ambassador of Norway in Brazil, Ambassador Odd Magne Ruud. Norway, as you all know, is a partner of the Brazilian country, especially as concerns preservation of the environment. So the Ambassador of Norway in Brazil has been here since 2009. He's a senior counselor of energy, climate, and food security of the Ministry of Foreign Affairs of Norway. He was senior counselor of government relations, public affairs, and international policies, as well as corporate communication. He was the general director of the International Affairs Department of the Cabinet of the Prime Minister of Norway, and he was also vice general director, head of the Secretariat Ministry of Corporation Development and Ministry of Foreign Affairs of Norway in Florida, the United States. The sum of his curriculum demonstrates that he is very much in a position to speak about this subject. So now we give the floor to Ambassador Odd Magne Ruud. Good evening, ladies and gentlemen. If I could sing, I would give you now a traditional Saminhoik. Unfortunately, my voice to sing is even worse than my Portuguese. As such, I will spare you tonight. I'd like to start by greeting my colleagues in the panel. Minister Justiça Associati Magalhães, Minister Justice Og Fernandes, Ambassador Kamariakis of Canada, and Ambassador Pendergast of New Zealand. I would also like to greet Minister Justice Herman Benjamin and Justice Maria Teresa, and also, of course, Lelia and Sebastião Salgado. Thank you for your wonderful pictures. It's a great honor to be here today in this closing panel of the first symposium about Indigenous peoples held at STJ. It's a tremendously important initiative to defend Indigenous rights. As we heard from the experts and defenders of the agenda in the last days, this is a historical moment in Brazil. Ever since the Ministry of Indigenous Affairs was created, we have a new situation of representation by these peoples in the implementation or execution of public policies in Brazil. I would also like to call attention to the stronger representation of Indigenous peoples in the Brazilian Congress. Parliamentary representation is something that I speak comfortable in speaking of, because in Norway, we have representatives of different peoples in the parliament. The Papias Sami peoples have had representation there since 1986. Usami in Norway also had a difficult history, problems like in the population in Canada and New Zealand as well. Now, the Sami peoples in Norway have the power of making decisions in terms of specific issues such as the administration of natural resources in terms of Saami areas, the preservation of their language and culture, as well as the development of policies that affect the population. And at this moment, I would like to avail myself of the moment to announce the visit of the president of the Sami Nation to Brazil next week, visiting Mrs. Jaqueline, the president, Cilia Mota, will participate in the National Congress of the launch of the next Parliamentarian Front to defend the rights of Indigenous peoples. On the 24th of April, this will strengthen even more the ties between the two legislative houses and will demonstrate the importance of international cooperation to promote Indigenous rights. Indigenous rights is a fundamental pillar in NICFI, the International Initiative for Climate Protection of Norway. The initiative is well known. However, few know the program to support Indigenous peoples that in 1993 will celebrate its 40th anniversary, working also in Brazil, 4 decades in partnership with Brazilian civil society, promoting rights and strengthening Indigenous associations and strengthening land use and planning in Brazil and Indigenous lands as well. I would also like to congratulate the Rainforest Initiative, the chief of which is present here today. This initiative is very important and it is supported by Norway. The virtual reality movie that I hope that all of you saw yesterday and today was produced by IRIS, which is a support platform for religious leaderships so that they can expand their contribution to the conservation of the forests. We believe that IRI has a tremendous potential to transform, and they are great partners of ours. Finally, I would like to thank the invitation and the opportunity of speaking to you here today. As Congresswoman Celia said yesterday, justice will be ancestral or it won't be. And here we are taking steps to bring people closer to see their needs and their rights, to do the right thing. Thank you very much. I would like to greet Ambassador Odd Wagner Root, Ambassador of Norway in Brazil, for his presentation, which showed an intimate partnership that exists between Brazil and Norway, not just in defending Indigenous rights, but very especially in defending our environment. As His Excellency pointed out, we are all very familiar with the Norway Fund to support the Amazon. As you all know, the federal constitution established that it's a right of all and the duty of the state to keep the environment ecologically well balanced for present and future generations. And His Excellency said, an expression that really impressed me. Justice will be ancestral. We of the judiciary need to resume this ancestrality and redeem our historical debt with the autochthonous peoples. With that, I would like to thank His Excellency and register the presence of Justice Maria Teresa de Assis Moura, who at the beginning of this panel I greeted because of the initiative of holding this symposium, which opens a space for debate in the court of citizenship to affirm the rights of the original peoples, Indigenous peoples. bringing this international approach to the debate, bringing nations that have also faced the same problems as Brazil in the fight and defense of indigenous peoples. So I would like to thank all the panelists for participating in this event. But before concluding, I would like to register that Article 231 of the Federal Constitution consecrates a historical right of indigenous peoples over their traditional lands, the lands traditionally occupied by them. We also need to record that the Brazilian state is still lagging behind in this point. The Brazilian state has the duty of ensuring the tenure of indigenous peoples over their land, protecting them from land grabbing by third parties. You must know that the statute for indigenous peoples in 1983 established a deadline for the Brazilian state to demarcate their lands, and it's only through demarcation that it will be effectively protected. This deadline has passed, and it was not obeyed. Another deadline is 5 years, what was established after that for the Brazilian state to demarcate indigenous lands, but that deadline was not fulfilled either. But the fact is that we made progress with the Constitution of 1988 because the Prosecutor General of the Republic, Raquel Dodge, in an article on the subject said, shows that the Constitution advanced on the matter because 90% of indigenous lands demarcated in Brazil were demarcated after the Federal Constitution of 1988. And finally, I would like to say that Brazil did advance in the legal instruments for protection of indigenous rights and communities. But as the Minas Court Drummond de Andrade said, it is not enough to have laws. Flowers are not born from logs. It is necessary for effective actions to be implemented, for public policies to be implemented, so that the powers constituted in Brazilian society in general can concretely implement the protection of indigenous peoples, establishing equality amongst all peoples, equal rights in this case, for indigenous peoples. And I'd like to remember here that the great thinker Alberto Bobbio said that the peoples today want to see their rights not just formally declared, but they want to see them effectively guaranteed and protected. And that is what indigenous peoples expect from the Brazilian state, that the Brazilian state is able to, through the constituted powers, through public policies, implement effectively the protection of the rights of indigenous peoples, because it is only in so doing that we will have a fairer world, a more equal world, a world with more social pacification. And with that, I close this event and give the floor back to the Master of Ceremonies.
Ladies and gentlemen, this concludes this International Symposium on Indigenous Peoples, Nature and Justice. We'd like to thank the Association of Members of the MET who have helped us bring this event to fruition, as well as the Ministry of Indigenous Peoples, the National Indigenous Affairs Foundation, FUNAI, and also Banco do Brasil, important supporters and sponsors. A great evening to one and all.